Item 1.
Item number 1.
I'm
Mr.
appearing for the
Signaria,
Yes, my lord.
this matter while preparing the judgment, I was having some difficulty. Difficulty is that
Yes, my lord.
there is, I am not able to follow what is the continuity. I mean, what is the note করছি sir. The sequence of events.
Yes,
Please
my
give
lord.
a note on sequence of events. I'm not able to follow it. The claims bill claimed by the respondent after completion of the work, seta nahi. The claims made before the completion of the contract, the work, seta bhi nahi. And the claim accepted but rejected by the appellant, seta nahi. So all these things, just can you make a note on all these things? Because
I'll make a note on it. I'll make a note.
Sequential note, because this sequence I'm not able to follow.
I'll make another note for that, for the claims, my lords.
Yeah. I would say the transactional history. Give a transactional history. That's better.
I'll make a transaction history and give it to my lords.
For the appellant is directed to prepare a transactional history of the case, so that
Mr. Sanjay is appearing for the respondent.
he is required to give that.
Your lordship has dictated appellant.
Huh?
Your lordship has
Oh, sorry, I'm so sorry.
My lords, I'm for the respondent actually in this matter.
No problem. You give it to that.
I'll give it, my lords.
Both sides. Both sides. Even from the side of the appellant side, both appellant.
My lord, in this case, my lord, Mr. Kashyap is suffering from
Kashyap je jantu apna koi debe tanku se de debe
my lord, he is suffering from dengue, my lord. So
dengue lo note banaya pe dengue suffering kon asida hoichi. Note ghare to basi note banebe aap.
I'll submit the same. I'll submit it. I'll submit it.
छोटा नोट टे बने ट्रांजैक्शनल हिस्ट्री किए कागु बेल रेज कला केते देला किए रिजेक्ट कला ये सब जिंस के दरकार था क्लियरली किसी मिलुनी से देयर इज अ लॉट ऑफ कंफ्यूजन आपण माने जो बनांती ना जो अपील बनाते अपील मेमोरी से सिस्टमैटिक कला ये सब प्रॉब्लम होता नहीं अनफॉर्चूनेटली जे जहां अच्छा चिपके दोछंदी खाली आर्बिट्रल अवार्ड चिपकेले जहां अच्छा जोड़े जोसी next
I will provide this.
Yes. Within 3 days. By Monday?
Yes, my lords, I'll do it by Monday. By Monday, I'll submit it by Monday.
Both of you by Monday. Tell Mr. Kashyap we can prepare notes still. Even if he is suffering from dengue. Okay, next.
Item number 2.
May it pleases my lords. The petitioner challenged the inaction of the opposite parties in not disbursing the compensation amount to a deceased COVID warrior man. Deceased COVID warrior man. Compensation of rupees 50 lakhs.
कौन करथिले से कि
So here the sarpanch of my lords.
सरपंच कोविड वॉरियर कौन कॉलेज कौन करथिले से
The state has given the direction to all the sarpanch of the districts, my lord, to carry out the COVID management in the rural.
COVID warrior खाली कहि सरपंच वाले COVID warrior self declared COVID warrior.
No, not self declared, my lord. It is not no, it is not disputed by the state that COVID warriors sarpanch are not COVID warriors.
कौन करछि कि स्टेट कोन इठ जान भुवनेश्वर
My lord,
सरपंच गां रे कौन करछि स्टेट कोन जान
state, my lord, the state has given direction.
मेकैनिज्म तक जानिबे जे से कोविड वॉरियर थिला बोली
My lordship may kindly have a glance at annexure 3.
खाली सरपंच जंदी आजिकली स्वाधीनता संग्रामी जो भत्ता मागी अछि स्वाधीनता संग्रामी केबे से छिडा भी ही नथिबो એટલે स्वाधीनता संग्रामी पे सब भत्ता मागी
He was a COVID my lord, sir.
नहीं मु जाने कोविड वाला केमती
Annexure 3, my lord. Annexure 3.
has he been certified as covid warrior के सर्टिफाइड करछि
When during the COVID times,
कोविड वारियर से कॉल केते कोविड वारियर फेसबुक रे बुलुथिले देखि सत्य केते सेदरे सतरे कोविड वारियर केते एमदी नकली सेटा देखिर अछि ना कोविड वारियर 50 लाख
the health workers, the police personals, as well as the municipality workers plus the sarpanch man.
ये सर्टिफाई करिवो full certified to be a covid warrior.
The health and family welfare department has given.
warrior मु कहि देबे लहिगला घरु बाहर नथिबी केबे हेबो कोविड वॉरियर सर्टिफाई के करिवो मिस्टर महापात्र हु सर्टिफाइज टू बी कोविड वॉरियर
The Department of Panchayat Raj, my lord.
पंचायती राज
हाँ।
तो सरपंच को कराइछि
गोटे गोटे नोटिफिकेशन आसिला से नोटिफिकेशन बेसिस रे सेमानकु कोविड वॉरियर फ्रंट लाइन कोविड वॉरियर बोल डिक्लेयर कले बट दिस केस इज आई एम डिस्प्यूटिंग द प्रेयर रेज्ड बाय माय लॉर्ड एंड फ्रेंड my lord. Kindly have a glance to first your lordship kindly have a glance to the page 9 prayer my lord. He is claiming compensation of rupees 50 lakhs. 50 lakhs. Now your lordship kindly have a glance to the death certificate which was issued by the competent authority.
Annexer 2
Annexer 2 21/5/2021
yes
तांका date of death. Next page.
Hmm.
There is no document, I mean the certificate relating to that the petitioner has died in
Age is
this is a
76
right to
चला
information act document my lord.
age is 76
My lord, lordship may kindly have a glance at page 13.
76 कोविड होने लगा
Lordship may kindly,
आवा
I pray my lord kindly, my lord, he has raised an objection.
Hmm.
Lordship may kindly have a glance at page 13 my lord.
ये 76
That is a death
लोग
report.
केते लोग कोविड वॉरियर काम
The
करथले
Sarpanch my lord, he was
Sarpanch
bound
so-
to be my lord, to do dispatch the
want to बता
my lord, collectors are also COVID warriors. To contain the COVID in the rural areas, which is the vulnerable one. my lord.
सर आमे जानी छु सर आमे भी रूरल एरिया रो आछु आमे जानी आटी कोन दर सारा ना
To get
आपण दर
whether-
आटा सर्टिफिकेट आपण
my lord, that certificate we have at the annexure 1 my lord. That is that do not shows which how the death had occurred. my lord.
Setra
It
kon
just says that death has occurred on this day.
सेटरे कोन
And
डेथ
we have
सर्टिफिकेट कोन
issued
सेटा
the
इशू
डेथ सर्टिफिकेट से
To
बोला
get how we have succumbed to death. my lord.
I want to know whether this man died of COVID or
My
not.
lord. Page 13, that is a column number 16 my lord. The third columns to the right.
This is a report.
Death report my lord,
It is prepared by whom? It is prepared by whom? It is
The
prepared
medical
by-
officer CHC Sinapoli district Nuapada my lord.
आपनकर पॉजिटिव थिला बोली आपनकर टेस्ट हेइतले से रिपोर्ट काई वेरी सिंपल क्वेश्चन
Medical officer has stated that.
नो
ନାଇଁ ନାଇଁ ଗୋଟେ ପୋର୍ଟାଲ ଅଛି ସେ
ହୁଁ।
ପୋର୍ଟାଲ ରେ ଏ କଲେ ବାହାର death
सेटा
ହେଲା।
एक्चुअली
all
सीडीएम
ଯାହାର ବି କୋଭିଡ ଡେଥ ହଉଥିଲା ସେଇ ପୋର୍ଟାଲ ରେ ଆପ୍ଲାଏ କଲେ ସେ ସାର୍ଟିଫାଏ କରି
सीडीएम सेटा को इशू करंती
ସିଡିଏମଓ ଇସ୍ୟୁ କରୁଛନ୍ତି ସେମିତି
गोटे लोगो भी हमर हॉलमार्क गोटे रोज तादर ओरिजिनल जोटा डेथ सर्टिफिकेट जोटा कोविड रे जोटा मर जनी
ଦୁଇ ତିନି ଆହୁରି ସେ ଦେଖେଇ
My lord,
ସାରିଲେ
kind of,
so CDMO issues a certificate that this person died of because you are claiming for this otherwise not problem.
my lord.
Since you are claiming the compensation because of the COVID death, that's why the certificate has to be issued by the CDMO, not by
Yes.
any Sinapalli doctor.
No, not
Sinapalli
not a not a
ପାଞ୍ଚ
not a
ଟଙ୍କା
regular
ଛାପା
or
ମାରିଦେବ,
a
କଣ ଅଛି?
something my lord, is a medical officer my lord, by the state.
Sir,
appointed by the state.
ସବୁ ଡକ୍ଟର ମାନେ ମେଡିକାଲ ଅଫିସର
No, no,
rural
it's kind of got annexure 2 your lordship, page 12.
ହୋଲ୍ଡର ଜଷ୍ଟ ଶୁଣ ଏଇ ଯୋଉ ଡକ୍ଟର ଏମବିବିଏସ୍ ପାସ୍ କରିକି ଯୋଉ ଜଏନ କରନ୍ତି ଯୋଉ ସିପିଏସସି ମାନଙ୍କୁ ସେମାନେ କଣ ହେବେ
MBBS doctors my lord.
मेडिकल
କିନ୍ତୁ ନା ଥାଏ ଏମିତି ଏମବିବିଏସ୍ ଡକ୍ଟର ବୋଲି କୁହାଯାଏ ଦେ ଆର୍ ଅଲ୍ ମେଡିକାଲ ଅଫିସର୍ସ ଦେ ଆର୍ ଅଲ୍ ଦ ଡେଜିଗ୍ନେସନ ଇଜ ମେଡିକାଲ ଅଫିସର
But they cannot my lord give any information
अरे
from the
भाई
RTI my
तो
lord.
नहीं
They can-
जानते क्यों आगे आर्ग्यू कर रहे हो फालतू में आता आता तो है नहीं ये कैनॉट की कैनॉट मेडिकल
they
ऑफिसर
can
कैनॉट
give only on the notepad my lord. They cannot give any
नोटपैड
RTI
बाहर
my lord.
नोटपैड कौन तो जानछ मेडिकल ऑफिसर वाले कौन जानछ किसी जाने ऐसे बकवास हो जाए सर दे परिबेनी ऑल आर मेडिकल ऑफिसर दे आर कॉम्पिटेंट टू गिव इट बट देयर सर्टिफिकेट इज नॉट एक्सेप्टेबल द सीडीएमओ हैज टू गिव इट हां जाने के खाली ऐसी ऐसे की
Also cause the new
हाँ।
lordship.
सीडीएमओ सर्टिफिकेट इशू कर आने देखिए
My lord,
you
so
get a
lordship,
certificate from the CDMO that he has died of COVID, I will consider. Get that. नहले खाली कोविड वॉरियर बदल ही जो ताले तो एते लोग कोविड में मर जे समस्त सरकार 50 लाख टका देला सरकार बैंकरप्ट ही 50 लाख कम हलानी
That's state furnishing my lord.
हो दे नहीं क्या सो देखिए
हेलो।
तो एमबीबीएस जो सॉरी सीडीएमओ सर्टिफिकेट ले गया लॉर्ड काउंसिल पिटिशनर टू submit the proper certificate issued by the competent authority regarding the death of the present patient.
Specifically.
I am granting you 1 month time.
My lord.
So let it come on 5th October. Hala?
Item 3.
3.
Today morning, I have written, I had come yesterday out. I have read the brief, but I have not prepared well to assist your lordship. Before submission, I beg to submit.
With
like this.
the opposite party.
Madam, the fact of the case is that the legal services
Oh,
authority.
acha, legal services.
Yes, legal services
Notice issue
authority.
any?
Pardon, my lord.
Notice issue any? Notice. Notice any?
Yes, matter.
No, notice that.
Press.
I have press admission,
So what is the issue?
my lord. They have imposed 3 lakhs cost on us. So that may be state
3 lakh cost for what?
for only, the fact is that, kindly appreciate. ROR, the sell deed, rent receipt and municipality approval certificate for construction of the house
Hmm.
and the registered sell deed. These are the 5 documents which were produced before the bank for taking loan, house building loan. And the person, the opposite party was an employee of the bank. There are 2 things. One is his house for construction. Another, he was an employee of the bank. So from his bank salary, the money was deducted, and ultimately he retired in the year 1919. 2019 he retired. For 20 years back, that document was produced. And that document was not traceable because of the fact that by shifting of the bank from one place to another, that file was not traceable. But the account was closed, and his all the things were also told to him, and also told that if we will get the document, we'll return you, and if you want urgently, then we'll get the certified copy at our cost and we'll give it to you. The registered sale deed 25 years back, that we can get the certified copy.
That is lost in your bank.
Yes, that is
Otherwise,
misplaced.
no other issue.
No.
Except for.
Except that there is no other issue.
I mean, he has repaid the entire loan, everything is there.
Everything.
So
And
no problem.
another thing is that he has also obtained a certified copy.
No, but for this reason, why he has approached to this Lok Adalat?
Local Adalat, before Local Adalat, Ombudsman, he referred the matter to Ombudsman. Ombudsman refused. And thereafter he filed.
Ombudsman refused, he didn't entertain.
Yes, he didn't entertain. He gave a speaking award that I don't want to entertain on this. This is petty matter. Bank also told that we'll give you the certified copy. The problem is that he filed a certified copy with other documents, grant me another 50 lakhs loan. Bank didn't refuse. He said immediately you give it. And a legal notice was also given to him. I have annexed those documents to show that you give me another 15 lakhs. Yes, it will take some time. And he gave a legal notice, and that if your lordship will see the legal notice, will know what is the purpose of legal notice.
No, this is in otherwise also. Why should
No, it is the fault of the bank.
The PLA will.
No, that's right, Mal. That's right. That they should not entertain such type of petty things. But the cost is 3 lakhs rupees, and any default.
I'm not. I'm staying that cost.
Yes.
The petitioner is the chief manager of the petitioner is the bank. Petitioner bank. Is by the order dated. Order dated
25/4/23.
2023 passed by the permanent Lok Adalat
Gunjar.
in PLA case number 303 of 2020. The main grievance for of the present petitioner is that the PLA has acted beyond its jurisdiction by granting an award to the opposite party quite disproportionately. Where is that order?
Order is annexed 12 manner.
He further submits that
Page 53, your lordship may kindly see.
he further submits that the bank to return all the original documents and within 1 month, failing which the bank to pay rupees 1 lakh towards the compensation for the loss, and also directed further to pay another 2 lakhs towards the compensation for causing deficiency in service and harassment. It has also related to pay rupees 1 lakh, rupees 10,000 towards the cost of litigation. This court deem it appropriate to stay the order, the award dated 25/4/2023 passed in PLA case number 300/2022, only disposal of the writ petition. Issue notice.
Requisites may be by Friday, my lord.
Filed by within 3 working days from today.
Friday.
But how can you not give the original document of a person?
My lord, the problem is that what I
I understand the
as
problem.
an officer of the
for
court,
that, you have
no,
to
no,
pay.
that I have also avoid one paragraph.
Fine,
Because
but-
he was every access.
Other things maybe, but for the not delivering the original documents, you have to pay something.
No, that's right, my lord. That I agree. But one thing is, my lord, the bank has-
1 lakh rupees you have to pay for the document. That I'm not going to.
and that will see at the time of
Other 2 lakh and 10,000 that I can.
that will see at the time of argument.
For the
I'll
time.
convince you also.
Unless the matter on 11th October. Next,
My lord, requisites by Friday because
by
2 days are holidays.
by 3 working days from today.
Because
3 working days, sir.
I'm in accommodation.
Sir, 3 working days.
That's
all.
it. Within 3 days, that is the rule.
Aji Kali bhi working days hamara. Saturday bhi
Yeah,
working
yeah.
days.
Obliged.
Okay, good. Pardon bhi working days. Mara tapara.
No, Kali khali work.
Kali working day, Monday bhi working days.
Monday mu accommodation ରେ ଅଛି because of my personal work.
ठीक है, आप file कर दो. Okay, next.
Item 4.
May I please, my lord? My lord, what happened in this case, my lord? My lord, brief of the case, my lord. My lord, +3 second year ର ଗୋଟେ ପିଲାଟିଏ ସେ ଗୋଟେ +2 first second year ର ଦି ଜଣ ଯାକ
SI Trinath Bhoi, Constable Swanso of Bhadrak Police Town Police Station, Odisha, were returning with the victim girl and accused Amrit Puhan, son of Swanso, District Bhadrak, State of Odisha, in Falaknama Express.
my lord.
After recovery of the victim lady and arrest of the accused Amrit Pradhan in connection with their Bhadrak Town PS case number so, Anitiki, the accused Amrit Pradhan jumped from the Falaknama Express train in
भाई,
running
jump
condition.
करছি कि पहली दी जाड़ा के दी जानी भी
No,
जम्प लिखिबो ना पुलिस अकाउंट लिखिबो
এটা তো ଆମ ପୋଲିସ ଲେଖିନି, ଏଟା ତାଙ୍କର ରିପୋର୍ଟ,
ତା
ଏଟା
police
ତାଙ୍କର
report।
ଏଇଟା ୱେଷ୍ଟ ବେଙ୍ଗଲ ପୋଲିସର। ସିଏ କହୁଛନ୍ତି ଆମେ କଷ୍ଟଡିରେ ଆମ ପୋଲିସ ତାଙ୍କୁ ବାଡେଇକି ମାରିଦେଲା ବୋଲି। ଯଦି
ଆପଣ
ଆଚ୍ଛା ଟିକେ
ହଁ,
ସାର୍ ଟିକେ
କହିଛ, ହଁ କୁହନ୍ତୁ।
ଏଟା କଷ୍ଟଡିଆଲ କେମିତି ହେଲା?
ମାଇଲର ତାକୁ ଧରିକି ଆସୁଥିଲେ, that is called custody, ମାଇଲର। ପୋଲିସ ତାକୁ ଯେତେବେଳେ ରେସ୍କ୍ୟୁ ପୋଲିସ ଭିତର ପାଖକୁ ଜଣେ ପଳେଇ ଆସିଲା ମାନେ that is custody, ମାଇଲର। ପୋଲିସ ଯେତେବେଳେ ତାର କଣ୍ଟ୍ରୋଲକୁ ନେଇ ଆସିଲା, ସବୁ ଭେରି ଇମ୍ପୋର୍ଟାଣ୍ଟ ଥିଙ୍ଗ ୟୋର ଲର୍ଡସିପ, ତାଙ୍କର ଇଣ୍ଟେନସନ ହଉଛି କେବଳ ମାରିବା। କାହିଁକି ମାଇଲର ସେମାନେ ଏଠୁ ଫ୍ଲାଇଟ ରେ ଗଲେ, ଫ୍ଲାଇଟ ର ପଇସା ବି ମାଇଲର ଗଭର୍ଣ୍ଣମେଣ୍ଟରୁ ସେମାନେ ନେଇନାହାନ୍ତି, ଯାହା ଆମ ପାଖରେ ଇନଫର୍ମେସନ ଅଛି। ଝିଅର ବାପାଙ୍କ ପଇସାରେ ଫ୍ଲାଇଟ ରେ ଯାଇଛନ୍ତି ସେଠି।
पुलिस तांग बाबा ଝିଅର ଇଏରେ
ମାଇଲର ଭେରି ଇମ୍ପୋର୍ଟାଣ୍ଟ ଥିଙ୍ଗ ଇଜ ଦ୍ୟାଟ they are not following the DKBS guideline, your lordship।
ସିଲଭାସା ବାଲା ଧରିକି ଆସିଥିଲେ ଏଠି
ସିଲଭାସା ଆସିନାହାନ୍ତି, ଆପଣ ଦେଖନ୍ତୁ ସିଲଭାସା, ଆପଣ ଏଇ ତ୍ରିନାଥ ବାବୁ ହଉଛନ୍ତି ଭଦ୍ରକର your lordship। ଭଦ୍ରକରୁ ସେମାନେ
ଆଜ୍ଞା ସେ କଲିକତାରୁ ଭଦ୍ରକ ବାଲା ଯାଇକି କଲିକତାରୁ ଆଣିକି ଆସିଲେ। ଆପଣ ବମ୍ବେରୁ କେମିତି ଆସିଲେ ସେଟା କୁହନ୍ତୁ।
ଆପଣ ଦେଖନ୍ତୁ
ଖାଲି କଲିକତା
ମାଇଲର ସେମାନେ ଯାଇଛନ୍ତି ଆଣିକି ଆସିଛନ୍ତି, ସେମାନେ ତାଙ୍କର ଆଫିଡେଭିଟ ବି ଦେଇଛନ୍ତି ମାଇଲର। ମାଇଲର
कुछ भी बोलते हो।
अच्छा just
ମାଇଲର
which is the police officer they went to Bombay?
ମାଇଲର
Which is the police?
ମାଇଲର 3 ଜଣ ମାଇଲର।
ନା
ମାଇଲର ତ୍ରିନାଥ
ଭୋଇ
ଭୋଇ,
एसआई
ତ୍ରିନାଥ ଜନ୍ମେଜ ବଳ, ଆଉ ଜଣେ ମାଇଲର, 3 ଜଣ ଯାଇଥିଲେ ମାଇଲର।
the 3 police को डाका
ମାଇଲର
all these 3 police be called here.
They have also
ସେମାନେ କୋଉଠି posting ଅଛନ୍ତି ଏବେ?
they have also filed counter in CRLMP ଯେ ଆମେ ଆଣୁଥିଲୁ, ଆମେ ଯାଇଥିଲୁ ଫ୍ଲାଇଟ ରେ, ସେମାନେ ଆଣିଲେ ସିଲଭାସାରୁ କୋଲକାତାକୁ ଫ୍ଲାଇଟ ରେ ଆଣିଲେ, ଆଉ ଝିଅର ବାପା ମା ସାଙ୍ଗରେ ବି ଥିଲେ।
let them. Let these three police, they are posted where? Where are they posted now?
ସେତେବେଳେ ଥିଲେ my lord town rural
CRLMP Prasanna Shekhar Mishra, officer in charge, Bhadrak Rural Police Station. He has filed this affidavit. ये से कहले rural PS
ये जाए भद्रक SP को भद्रक SP to produce the three police officers.
No,
My-
one officer, two constable.
Okay, the one officers named
Trinath Bhoi,
named Trinath Bhoi,
ASI.
ASI,
Constable Sanmoy
Sanmay
Patra,
Patra and Janmenjay
Janmenjay
Pal,
Bala.
who went to Mumbai to recover the victim girl. The policemen were stated to be working under Bhadrak Town Police Station,
rural
rural. ये भद्रक टाउन लिखाई जी, भद्रक टाउन लिखाई जी.
my lord.
The SP Bhadrak to ensure their presence before this court on Monday.
ताकू नियरेस्ट मैजिस्ट्रेट पाखर भी प्रोड्यूस करना
से आसंतु ना से देखिए.
आपण भी डायरेक्शन देले छे जो 302 रे चार्ज शीट फाइल करिया पई
It will come to physically.
आज जाय भी चार्ज शीट फाइल हेनी आपण डायरेक्शन करेनी
Physically.
But a free copy. No?
Physically to be on Monday na Tuesday कर दिया. Let's see.
Obliged, my lord.
Next
Item 5.
at 12:30. 12:30.
May I please? Honor?
12:30.
Yesterday, similar matter was before my lordship, and she issued a notice. Item 5. This is a case, my lord. Petitioner's daughter died, was a victim of rape and murder. Made
Similar order कोड होगा.
sir gola kali do gola
Similar
kali
order टा दियो.
no sir gola kali do
बोला कल.
gola kali item 5
Notice करती.
notice issue होची
Similar order कर. दियो दो.
1 to 1 4 को extra copy दे 1 and 4
Okay, next.
item 6
May I
Six.
please your lordship? I am appealing through virtual court Kalahandi.
Six.
May I please my lordship? My lordship, petitioner has a only son named Paramananda Putel. He is died by the hit and run accident on 11/7/2021. There is a sanction amount of 2 lakhs, my lordship. Under the scheme of
By which?
opposite party 3, the order has been passed.
No. Hit and run. Who hit whom? कागो की hit कला.
May I please your lordship? I am appealing through virtual court.
You are for whom?
We are associate, my lordship.
तो जणे को ना जे कोचा डिसाइड करो तम भितरे जे एठी आउ से वर्चुअली कहबे आपण एठी कहबे कोन चलछि.
Let him virtually speak.
तो वर्चुअली वाला चुपचाप बस.
Yes, my lordship.
Sit down. हाँ. Yes, Mr. Pat Joshi.
Your lordship, the petitioners are husband and wife. Their only son, Paramanand Putel, he died on a hit and run motor accident at Utkela under Kesinga police station on 11/7/2021. May I draw the kind attention of your lordship to annexure 3, page number 11. This is the sanction order by Claim Settlement Commissioner, that is the OP number 3. The amount of 2 lakh has already been sanctioned under the scheme Solatium Fund of Orissa, but it has not yet been disbursed since 14/10/2022.
Okay. Now, constable petitioner submits that though the regional transport officer Kalahandi, sorry, the claim settlement commissioner, video order dated 14/10/2022 has granted compensation of rupees 2 lakh in respect of the death of the deceased Paramanand Putel, P-U-T-L, Putel, who died from hit and run motor accident, which took place at Utkela on 11/7/2021 at about 7 a.m. in the morning. Since the claim settlement commissioner has already granted the compensation to the petitioner, the sorry. Though the claim, petitioner, the said amount has not yet been released in favor of the present petitioner. Hence, is constrained to approach this court. Issue notice to OP number 1, 2, 3, 4, 5, 6.
OP number 2, sir, is the transport authority. OP number 2 खाली तांको notice हेले भी the purpose
Right.
will be.
Fine. All of this. Issue notice to all of this. Give a copy. Give copies to Lord Counsel the petitioner to give extra copies. 5 copies to the party. List the matter on 3rd October.
Much
Take-
obliged, sir.
Take instruction on that. You have agreed, there is no dispute on that. The commissioner has already sanctioned it. Only you have to release the money. There is no dispute about that issue.
Much obliged, sir.
Next,
Item 7.
ensure that money is paid before the next date. Unnecessary, don't delay it. Take the land council, this state to take steps and convince the department to pay the department. Okay. That's what the case.
Item 7.
May I please, Your Worship? This is regarding selection of Hon'Ble worker under the opposite parties. So far the selection is concerned, the present petitioner and the opposite party number 6. The petitioner though belongs to, kind of a glance to page 21 for a moment, my lord. It is
Let
at
me
annex.
first, what is the issue, then we'll glance to.
Issue is
Glancing in next, first. State the facts.
issue is, though I have secured more marks and having the resident certificate of that particular area which has been earmarked by the authority, the person who has selected, she has no valid certificate as per their remarks, but she has been found selected and given appointment. That is at available at page 21 at annexure 4.
The petitioner has referred the present challenging the arbitrary selection of the Anganwadi worker in the village Krishna Daspur, Rayarpur,
Rayarpur.
Anganwadi Center. in the
Rayarpur
ward number
Co.
7 in the district of Jagatsinghpur in arbitrary manner. He further submits that the selected, the present petitioner is he has secured higher mark than the candidate selected. that
Having
is
the
OP number
residence.
6. However, on the basis of the
Not having the residence
not
certificate.
having the residential certificate, the petitioner has been ousted from and
Select.
zone of consideration. You have not been selected at all. no?
I have not been sure.
Zone of consideration. And the OP number 6 who has been selected for the said post doesn't have the valid residential certificate.
Yes, I have got the bill. That is, they have,
I am asking about that other candidate. She has
other have, not.
she doesn't have.
No, they have said verified resident certificate not valid. That is the remarks.
Valid certificate. Till the authority has went ahead with the authority went ahead with appointing the OP number 6 as the Anganwadi worker. Hence, it's constrained to approach this court for this proposal. Issue notice, OP number 1 to 6, 1 to 5.
1 to 5 extra
Subs-
copy.
Extra copy on the council for the 8, 6, maybe south through registered post. List the matter on 27.
And may I pray that not to act upon so far because it is a recent decision of 25 Act. They have published this annexure 4.
So what is that? They are going to appoint?
Exactly.
He is not appointed. He, the opinion officer has not been appointed.
I have got the information that yesterday they have handed
Huh?
over.
Huh?
Yesterday only they have handed over the letter of appointment to the.
The
opinion
letter
officer.
continue. If it is wrong, it is wrong. It will be dislodged.
Then
Put it
subject to
down.
result मिलन में से.
नहीं से चालू
I
कौन
नहीं I mean
से
protect-
चालू असुविधा कौन है
नहीं, मोर
लादा
से
जदि
तो
से wrongly ही तो ताको पढ़ा जीव आपण जीव कौन असुविधा अछि that we are doing regularly.
नहीं, let that be subject to result at least because
She already appointed, then what subject to result? Nothing.
it is
No, that Hon'Ble center can't be just left vacuum. Somebody should be there, na?
नहीं let if at all appointed let that be subject to result but that I will be protected.
Why your protection? You are nowhere in the picture. Where is the protection? I can understand you are working and you are
No,
going
not
to
working.
dislodge.
It is a new Hon'Ble center.
Then wait for that. Let it come and see. If wrongly appointed, she will be out. That's
Or
all.
fixing it too.
27.
Then
Next.
OP number 6 by rested post में से.
Rest.
Otherwise extra copy I will be
Rest,
served
rest.
so far the 1 2.
Yes, yes.
Fine. Oh, deep blue.
File the requisite. Shall I? Next.
Item number 8.
8.
May I please, Your Lordship?
What is this?
Order dated 6/7/2022.
What is this IFS? Lalit
Kindly
Kumar
have a
Tiwari?
glance to page 10.
What is this? What is the case?
Case is that petitioner is a unemployed. He
Hmm.
constructed a poultry farm house.
So
for-
how
for
this
the-
Lalit Kumar Tiwari is a contemner? Poultry farm तो कला ठीक अछि तापरे
Again. Tapore one of the villager made allegation, filed a writ application before the Hon'Ble Court
गंदुची को जो
making false allegations.
फॉल्स
this-
केते किलोमीटर केते मीटर डिस्टेंस अछि गंदु
ऐसे बिलो मझिरे करूची.
केते दूर पचार से बिलो
से बिलो ए जो
को गां रे गां लागि करी बिलो थाए
ना ना
आपण से गां रो डिस्टेंस केते
500 मीटर खंडे दूरे रे से करूची पोल्ट्री
500
फार्म.
मीटर दूर ना भीतर
Anyhow,
ना ना एनी हाउ नहीं
ना, नहीं,
500
मु-
डिस्टेंस
मु-
रे
मु-
रिसेट करा जाए
मु
500
टिके-
मीटर रुहन तो तुम
आगे।
आंसर तो दो ना दी आपण
आगे
रूल कहूची 500 मीटर बाहर आवा कथा आपण गोटा 500 मीटर भीतर ना बाहर
पा-
सेती कोन
500 मीटर 500 मीटर दूरे रे.
दूर रे
आगे से फिर बिलो मझिरे.
तापरे
One of the villager
कंटेम्प्ट ताले कोन हला
I filed writ application before this Hon'Ble Court
Tapare?
with certain allegations.
तो
This
तापरे
Hon'Ble Court disposed of the same
जा
on 12
explanation.
20 directing the State Pollution Control Board to make an inquiry and give a report, and till that date there will be status quo.
Okay, so
Construction काम सरी जाइछि. Status quo रहला 2 वर्ष पर्यंत किछि inquiry कलेनि कि pollution board किछि report देले नाही. तापरे आउ गोटे रिट एप्लिकेशन मु आसिली जोथरे कि डायरेक्शन हला 2 मास भितरे जहाटा फाइनालिटी करूचो तमे कंप्लाई करो रिपोर्ट दियो ताकू कंप्लाई वर्तमान सुधा भी करूनांती. एट पेज 10 काइंडली हैव ए ग्लांस
okay.
लास्ट
Notice-
पारा.
Issue notice to why you have the made party to this man?
Contempt proceeding will be initiated,
जी
will be filed
आज्ञा से लोकड़ा किए
against
कहाँ- कहीं
designation
कहाँ रे, कहीं
देइछ
किए से?
designation पर देइछ कहूछ.
से काहे के रेस्पॉन्सिबल हम बोल ये से लोग
Contempt ललित कुमार तिवारी
अरे ना,
member
लगाई
secretary
तो
for
भी
state
हाँ?
member secretary state pollution control board.
मेंबर सेक्रेटरी स्टेट पोल्यूशन बोर्ड में हूं
आज्ञा से दी जण जेहेतु पार्टी थिले कंटेम्प्ट बाय नेम करा जाय.
हमें जाननु के बैन करा जाए
ना 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 मु सेहिति पई ताको पार्टी करछि.
सेति पे हम पचार
आज्ञा।
लोगड़ा किए जाने लगा ना तो मेंबर सेक्रेटरी पोल्यूशन कंट्रोल बोर्ड
आज्ञा
तो issue notice to the contempt मैं arrested post ताको दे दो ना ये जो पोल्यूशन कंट्रोल बोर्ड से जो काउंसिल को दे दो अच्छा दे 3-4 जण
नोटिस जाउ किए तो काहा को देले से
मासे रही दो आपण आपड़े आ कर आसीबे
अच्छा, हम-
जल्दी शॉर्ट डेट
देखे
I'll give it Tuesday the day, next day.
आज्ञा मु दे दी.
आपण प्रॉब्लम सॉल्व करे चाहो ना जल्दी
ना ना मु दे दी.
दौड़ेबे से क्लाइंट को 10 लाख आपण पाक
ना ना मु
दे दियंतु एडी
ना ना मु दे देबी गोटे डेट
ट्यूसडे करछि
ट्यूसडे
ट्यूसडे आज दे दियंतु ट्यूसडे हे दियो
आज्ञा
मिस्टर मिश्रा को
BP Das, Vikram Das. Okay.
I'm fixing it for the state. Fifth crop. Fifth.
Fifth,
हाँ.
eighth,
ଆଜି ଦିଅନ୍ତୁ ମୁଁ ଫିଫ୍ଥ
ଆଜ୍ଞା,
କଣ କରୁଛନ୍ତି
ଆଜ୍ଞା,
ବହୁତ ଜଲ୍ଦି ଆପଣ
ଆଜ୍ଞା।
କାମ ସାରିବେ ଆପଣ ଗୋଡଉଛନ୍ତି
Aji Dedu.
ଆଜି ଦିଅନ୍ତୁ
ଆଜ୍ଞା।
ହଁ ଫିଫ୍ଥ ରେ କରିବା
ଆଜ୍ଞା।
ହଁ ଆପଣ
କପ-
ଯେତେ ଜଲ୍ଦି ଦେବେ ଏତେ ଜଲ୍ଦି ହବ
Okay, copy mu Aji service.
ହଁ ଆପଣ କାଇଁ ଡିଲେ କଣ ଏକ ମେଣ୍ଟାଲିଟି କାଇଁ ନା କଣ
ନାଇଁ, delay-
ଡିଲେ କଲେ ଗୋଟେ ମଜା ଖୁସି
ନାଇଁ ନାଇଁ ଚାରି
ବିଚାରା କ୍ଲାଏଣ୍ଟ ଖୁସିରେ ଜଲ୍ଦି ଆଇ ୱାଣ୍ଟ ଟୁ ଫିନିଶ ଇଟ କ୍ୱିକଲି
ଆଜ୍ଞା
ସେ ଲୋକକୁ ଡାକିବି
ଠିକ
ହଁ।
ଅଛି ଆଜ୍ଞା problem ଅଛି।
Item number 28.
But I am grateful obliged that your lordship was pleased to direct for personal appearance because the bank officer without any assigning reason had declined, one line declined and not accepting the personal guarantee, which was more credit to ordinary persons have been already substituted that matter.
Let me ask him. Let him answer what is
Obliged.
my officer
is present.
yeah just can you just,
May I,
yeah, I'm asking few questions.
Yes.
before my lord asks questions, my lord, I will only want to point out what the petitioner has stated in his petition. The reasons for giving guarantee and why he wants to escape from that.
My
We'll
lord
see
is
that,
ask-
sir. I'll see both the sides.
Yes.
Yes.
If matter will be hard, it will be so. My
No,
lord
that-
has directed.
Okay.
Why you are, my lord, this is his own statement. That's why, my lord, I want to point out. My lord, may kindly see. Only small portions.
It was already made. My lord was asking, sir, why is not? If you will argue, then we will argue. Then after we will argue.
No.
My lord is asking.
Your statement I am pointing out.
Let him do.
Huh.
He was yesterday, he was in VC mode. So
Yes.
please,
Let him
please
argue.
sit.
Yes.
Please sit down.
Right, my lord.
Yeah. Let
Sir
him
was-
complete that question. Please sit down.
But paragraph 3 may be seen of the writ petition.
3.
3. But in fact, this is from the beginning, it's not necessary, but I am to place because that the fact of the case is that the petitioner was initially appointed as salaried employee with the Magnum Group of companies. Since 1993, he has served the companies in various posts and capacities, and ultimately he was appointed on 12/8/2010 as director occupier of the aforesaid companies. Thereafter, the petitioner for over a decade, that other 4 lines are maybe left. The petitioner for over a decade was working as director and occupier of Messrs. Magnum Seafoods Limited and Magnum Estates Limited. Because of the official position in the above mentioned 2 companies, the petitioner had given his personal guarantee for the loan availed by these 2 companies from 2 different banks, such as State Bank of India and Indian Overseas Bank.
So he has given guarantee on his personal capacity.
His personal guarantee he has provided because of his-
for the company.
Yes.
For the company.
But may kindly see thereafter, with paragraph 4, he states the amount of loan availed.
Hmm.
But that is from State Bank, he availed 20 crores
15 crores from IOB and 20 crores from SBI.
SBI and 5 crores of LC, letter of credit.
LC, letter.
But thereafter, the next paragraph
So total you have 25 crores,
from State
including
Bank of
S,
India.
including LC.
Yes. But thereafter, this next paragraph that is unnumbered.
Now the question is, yes, Mr. Sadangi is right.
Yes.
So when you are working as an employee of the company, you just you had given the guarantee.
No, not
You are a
company.
guarantor at that time.
He became a director and
Now still you are holding the
Share.
share of the company, right? So you may not be having that post earlier as you were
Yes.
having,
My obligation.
but you are at present the shareholder of the company, right?
Right.
So when you are there when the loan was taken, you are the personal guarantor. So why? I mean, do
Yes.
you want to change this?
Yes, I want to, my lord's
guarantor?
question. I was working, then I became a director.
But
Then
the
I.
question is,
My lord,
is the change permissible or
yes,
not? That is up
yes.
to bank to decide.
it is, my
That
lord,
the
it
court
is, my lord,
cannot
my lord, I'm coming.
force the bank to.
I'm coming, my lord. Yes. Bank in several cases has substitute because the company has placed his collateral security of 20 crores. Along with that, my lord,
Maybe, sir.
my lord, I'm
But he
coming.
might have a place,
My lord.
but as a person, you have
Personal,
guarantee.
because personal guarantee 3.8 I'm shareholding. I give personal guarantee along with the company's other
What is
directors.
the guarantee of what is your worth?
Only 3 crores somewhat my share is in the company.
No, your worth. Personal. What is the guarantee? Guarantee
The
worth?
3 crores
Who are you?
somewhat.
Who are
Well, let me explain.
Who are you?
I
Who
have
are
got the
you?
company, my lords, in which the same director has given the personal guarantee to the bank, my lords.
Better. Better.
So my lord,
When I'm
yes.
I'll call then you'll
but
answer.
every year company has pledged his own collateral security. All directors have signed, they have also signed. Along with that, I was, because an employee, as a director, some personal guarantee of 3 crores somewhat was given. But my shareholding is very, very negligible in the company. But when I died or resigned, even today I died, how can they recover personal guarantee? So my resigning means I not given go back to my earlier company. I started my own entrepreneurship. My civil score is now at what basis of business, my civil score is there. Now the company already written a letter. Yes, this my ex-employee has already left. We are also substituting more credit to this person. And bank administrator has done in many cases, I can file affidavit. The personal officer deliberately sitting on the 1-9 decline. What is the reason? One bank has already released my personal guarantee. This state bank.
This is you cannot force them.
No.
Bank to bank, suppose X bank has given that.
Yes.
That's their
Well,
prerogative.
it is just
You cannot
arrangement.
question that.
No,
X,
it is just an arrangement. Suppose the parent company to be asked to give more credit. Suppose tomorrow more कम हैला मु छाड़ देली से मेन कंपनी जे 20 कोटी टंका लोन नहीं बिजनेस करूची ताकू कहबे तू मते आउ एई लोक बदल रे तू दबु इमती अरेंजमेंट आज्ञा बहुत केस रे हेछि तो माय humble prayer before my lord, the bank, if the could have asked the main company, yes, the substituted person, though more share, having more share than me, the Samidha Mahapatra is 5.8% share, where my share is 3 point somewhat. So the personal guarantee is ready to substitute. Even bank will ask every year their manager, the meeting is convened and the signature of the person to be taken. Last 2 years I have not given signature. My lord, last 2 years I have not signed.
But here,
let me ask.
But here the ground is different.
My lord, no.
That I was going to point out.
Please,
But the ground is.
This officer has done in many cases. I can file affidavit.
I have called the officer.
The DGM also doing. My lord, I can file affidavit. My lord was asking yesterday. In other cases, you have not done. They have done in so many cases, my lord. Why personal reason they have grudge on me because I have left out. Yes, let him file. Rightly, my lord has asked.
That I
rightly, my lord.
This. But paragraph, my lord, this on number.
I can file affidavit against the personal.
But that is the answer. But what he said, the company is involved in anti this. Kindly see.
Then you recall the loan.
Let him.
What will do? Well, that is a different thing. But he is now jointly and several liable under section 128 of the Contract Act.
No, you can't compel me to come and keep one substitute is done.
This is not done. He is addressing the court.
Sorry.
It is
Sorry,
not
sorry.
proper to
Sorry, sorry, I
interject in between.
beg apology, sorry.
Yeah, you are a senior man. Why don't you
Sorry,
respect
I
it?
beg apology.
Madam, kindly see this unnumbered paragraph from the middle. Further, the petitioner from reliable sources came to know that these companies were also indulged in illegal and clandestine transfer of funds to various sources, including foreign country. Moreover, there is no unsettled income tax demand amounting to several crores of rupees against the Magnum group of companies. It is pertinent to state here that petitioner on several occasions requested the chairman to refrain from such activities. However, the chairman of these companies, Mr. Ramesh Mahapatra, did not pay any heed to the request of the petitioner to refrain from these activities. Therefore, the petitioner intimated about the illegal activities of these companies to the Registrar of Companies of Odisha, Cuttack, on such and such date.
You are declared defaulter.
That is, he has stated in paragraph 6.
Magnum Seafood Limited may be declared a defaulter anytime due to gross financial and other mismanagement.
That was my apprehension because I have
You have
already
written
decision.
here your own
Yes,
apprehension. You have written.
but since
If you have your own apprehension, then why should the bank will not have the apprehension?
No, my lord, that is
Yes.
why the bank should have asked for more collateral security to the company or
See,
recall the
that
phone.
is there. See, we cannot compel the bank to see we do this or do that. This court doesn't have the jurisdiction.
Then
to
my
compel.
lord,
That is, see, they are doing financial business. They know better than what we know. They are quite competent to decide what to do and what is best for the interest of both the company and the.
my lord, bow down to your lordship's view.
So
But-
then we cannot compel.
No, I bow down to
If they are
lordships.
Not ready, not ready. What
But
can
my
be?
lord, bow down.
If
to
IOB has ready.
My lord,
to IOB, they are not ready.
the
See,
arrangement, adjustment, more credit to this has been done by
But
the
the
very same
problem
bank.
is that what you have written here, you have
Yes.
may be defaulter at any time.
No, default, that is why, my
But
lord.
you yourself has
Yes,
written.
yes. Because
That means
no,
you don't have faith in the company itself.
No,
And
be-
why the bank should
my
have
lord,
faith
I
in
have
you?
already resigned from the company.
You might have resigned.
And I
That's
have
why
no
there are
relation.
more apprehensive.
I have no relation. And bank has done in, my lord, several cases by accepting, receiving good
They might be
credit
doing
results.
so. See,
I can file affidavit.
there are cases to cases.
But in lordship,
Cases and cases.
my lord,
In X
the-
case they may do, in
Yes.
Y case
My
they
lord,
cannot do.
my lord,
That doesn't mean that the X case the bank has done means Y also
my
he
lord,
has to do it. No,
the
you cannot compel.
discrimination because,
No,
my lord,
not discrimination,
have-
nice, sir. Discrimination, they have to look into many factors. It is public money they are dealing with.
yes, my lord.
The public money, tomorrow something happen and they can't recover the money, then who will be responsible? The bank officer बेचारा अपना नौकरी गवा गया, क्यों करेगा आपके लिए? Why? He has CBI will against him. And what interest you have given, you have done this? He has to take care of his job also. They have to look at the both side.
My lord,
Huh?
my lord was rightly asking, declining my request. Your lordship, yesterday was putting question why bank has not.
So I am,
So-
to be very frank,
My lord.
I am not going to compel the bank. If the bank is
Well,
ready,
let
I
the
don't have any
officer,
issue.
let the officer to come, let me explain. If he can make done in many other case, I will
Sir,
file
other
affidavit.
cases and your cases are different.
If my lord, if further requirement will
No,
be there, my
You
lord,
are going to be in the defaulter list soon. You
No,
are
no.
yourself writing.
my
here.
lord, that is
So
why.
why should he
my lord,
give a
that-
defaulting
No, no,
person
that
to
is
do
why,
all this
my lord,
arrangement?
because I
Should
left
not
the
do
company,
that,
left
no.
the company, so I apprehend if company will
Sir,
become default. Now, today, till date, he has not defaulted. If at all,
They
if
might-
at all,
see,
so my
they are-
apprehension, my
They
lord,
are the best person.
My lord,
They are doing.
no, 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 my lord, why?
They
Because,
are doing the financial business. Day
my
in
lord,
and day
they
out.
have once
They are
admitted
well
that we are going to
decided
do.
How the money will be saved.
My lord, one
Whatever
occasion,
decision
they
they
have
take.
admitted they will put up this matter before our higher committee. My lord, once the committee has decided, kindly annex
The
to 6.
committee has
My
not
lord,
decided in your favor,
My lord, kindly-
unfortunately.
But that is one line
The
rejection.
committee has rejected, sir.
My lord, kindly see one line
They
rejection.
did not give a long answer to reject your this proposal. They don't
My
have
lord,
time
that is
to so many
unconstitutional.
things.
They have,
It is-
because if they want more credit to this person,
Yeah.
he is ready to buy a supply. And once similar bankrupt on
Yes,
his,
anyway, just-
where I'll go? Where I'll go, my lord?
Please sit down. Wherever you go, wherever you want to go.
Well, that
Why
is-
the bank has a ठिकानी ची bank
My lord,
का
that
आपण
is
उसे
why,
नाही, आपण
that,
पाण्याची
my lord, my humble submission,
bank
that is why bank
providing
is,
financial
My lord-
thing. And if you are not.
My lord, the very same officer, my lord, my allegation, the very same officer has done. Well,
Sir, many, that same officer might be doing.
My lord.
Why don't you just understand the poor man's job also?
my lord,
He will
My lord.
immediately nowadays, you
For-
know,
for more-
a
for-
small, just a
my
very,
lord,
a
only-
small mistake here and there, the
No, no.
CBI will immediately.
I bow down. Suppose 100 rupees.
Tomorrow,
I am-
tomorrow your company.
But
does
my
suppose you-
contribution is 3 rupees. If
I'm not
the-
going to see all these things. Please sit down. Let him answer. Yes, sir. Can it be possible of to substitute that other person is having higher credit worthiness? If it is possible, if your banking or your norms allow, if there is, I mean, no risk for you, then you tell us.
So actually, bank has given initially the loan, taking into account the person's credit worthiness,
I can hear you. No,
his
no.
net worth,
Hmm.
his stake in the company,
Correct.
all those things, sir. So all of a sudden, he is asking for his, releasing his personal guarantee. Sir, his personal net worth is still more than what we were offered, and still he is having sufficient stake in the company.
Hmm.
So at this juncture, sir, the bank has decided not to withdraw his guarantees.
He is saying, let it be placed before the higher authority. Just place it before higher authority. You have
Sir,
the
we
concept.
had taken up with the bank, sir, with the appropriate authority, and it was declined by the higher authority.
Higher authority. Any other appellate authority
No, sir.
beyond that?
No, sir. We have again to reroute through a different channel, and I don't know whether that will be accepted or not.
See,
So this is a corporate branch, sir. We are
I
dealing with
understand.
high credit, sir.
I understand, sir. I understand. So I understand
My
the
lord's right.
the problem. The
They
bank
have
is,
done in some cases.
the bank,
Let him-
they might have done.
Yes,
sir.
I bow down.
They have.
If my lord
case to
senior
case
was
I can
asking, if you'll put in some higher, he was, if possible, yesterday was.
Any, yesterday, Mr. Council was telling, council may not be knowing, he is the best person to
Yes.
answer this. He is personally present.
My lord.
Sir.
So is there any other way of just converting?
Yes.
Sir,
The-
I am the AGM and relationship manager for the accounts. My job is to take the relationship part of the company, sir. And my job is to put the things in proper perspective to the top authority,
Correct.
who takes care of all these things, sir.
Correct.
Whether to do it or not to do it. And a single person doesn't take the decision. It is the committee, sir.
Correct.
Some 4 to 5 persons sit there and decide, sir. This is the collective wisdom, sir.
Then if they are not, I can't compel them to do that. So this is purely their business tradition. If they are dealing with public money, I can't compel them. No. They can't be compelled.
Sir, if
You
I may
can
be
be-
allowed, sir, can I say something, sir?
Yes, please.
Sir, suppose, sir, if he comes now and asks for this, asking the honorable court to directors to do something, whether he has any other business relations with the bank or not, sir, and with what capacity is having those relationship with State Bank of India, and why is continuing there, sir? So tomorrow, sir, again, he will take the same plea there also, and he will ask for releasing his
No,
personal
no,
guarantee,
this-
sir.
I'm not, sir, one thing, well, just because somebody comes and I understand the position of the
Sir,
bank.
sir.
I very well understand
Sir.
the bank is dealing with public money. And even the bank, and also the business viability,
Sir,
your safeguard of your money.
sir.
All these things need to be looked into.
Sir.
If you are comfortable, you allow. If you are not comfortable, you don't allow. I am not going to compel any bank
Sir,
or
thank
any
you, sir.
financial institution for that matter.
Thank you,
Because you're public money, you're dealing with public money.
Thank you, sir.
So if you are not doing it, why should I compel? That's why I wanted to know what is, sometimes some things, because you're the person you are dealing with every day, you know better than the council sometimes on many issues. Maybe they are legally, they may be very well equipped, but financially, how it will impact on your banking business as well as on the other side. So better, you are the best person. So why should I just, what, if we are not accepting, I'm not going to do that. Not. If bank is not acceptable, bank is not doing, I can't do anything. Sorry.
My humble submission, my lord,
Sir, I can't do.
2 minutes, my lord, just 2 minutes.
Yes.
I signed in 2020. And when I was a director, I resigned 2021. My lord,
Sir,
in the
matter
meantime,
ends when the bank says no,
My lord,
matter ends.
my lord,
Not-
my lord,
no more,
why?
no more
the
argument.
bank, why I'm telling,
I am not saying anything. I am not going to
bank,
say
my lord,
anything.
in last 2 years, I have not signed as a capacity of
Sir,
a personal
that
guarantee.
is your personal
And, my lord,
problem
that is-
there. I'm not going to hear all these things. Sorry. I'm sorry. Next time.
So my humble submission, my lord, let the matter maybe at least at least because the AGM cannot take a decision.
But he at least he can
but they are-
throw
they are-
some light.
my lord, they are
He is a
refusal.
responsible
My lord, they are
officer. How does he
refusal.
not take
But their
decision?
refusal one line.
Hmm.
Let the committee, because they have done in so many
The
cases.
committee has already rejected,
My lord,
sir. Committee,
my
committee is
lord,
not this person.
That is why he,
group
my
of
lord,
people.
he is saying if at all you will be rerouted,
No.
let the matter be
No,
placed.
I have rerouted.
And in the meantime,
If
I
they
may
are
be
not
permitted to
interested,
file
Sorry,
affidavit.
sir, I can't.
I may permitted to file
I-
affidavit. My lord, at least next
You
week.
withdraw it if you want to,
My lord,
otherwise I am dismissing.
My lord, kindly see the predicament. I am a new entrepreneur
Sir,
now.
you may be, you need
My lord,
to, I am,
lord,
see,
I am a new
is the
entrepreneur.
court responsible for your.
And once, my lord,
Not,
tomorrow, if the loan
I am
is-
not going to say anything on that. That is up to your business. I'll only say the bank, if the bank is saying no, means no. I cannot compel the bank to, because my duty, I have already
my lord, kindly
told
see
you.
the order.
Bank court duty, each court is a काजी. मियाँ
Madam,
बीवी राजी तो क्या
Kindly
करेगा
see
काजी?
the
बस.
last order.
अब
Madam,
मैं
kindly
मेरा
see-
रोल काजी का रोल है. I
Order-
can't compel.
Kindly
शादी
see the
इसको
last
शादी
order.
कर लो.
Kindly see the last order.
Necessary.
And in the matter, my lord.
I am not hearing out further.
My lord,
Sorry, I am
swear-
not waste
No, my lord,
time.
I am kindly to put it next week. I am filing a my
I
lord.
have next week, next
Again,
side.
can't
I
go
will
to-
rock him.
Bank cannot deny, my lord. I will
Sir,
file.
cannot
this.
deny means what? You can
Cannot.
compel the bank.
My lord, they
Can
have
you
done in
compel the
other
bank?
cases, my lord.
Sorry, sir, you can't.
Kindly see just one.
This is as if ଆପଣଙ୍କର bank ମାନେ ବାଧ୍ୟ ବାଧ୍ୟ ଏମିତି କଥା
Counter ଦେଇନାହାନ୍ତି see ଆଜ୍ଞା.
counter mediation ଛାଡ଼ନ୍ତୁ ମ.
Kindly,
Counter-
kindly
they-
consider,
they-
my lord.
They
Kindly
have already they have filed it.
Well, kindly
said-
consider. I just small date. Just for lordship.
ये डेट चैट कौन टा
I
करो?
put up next week, my lord.
किसी
Kindly,
put up next
kindly
week.
move
ना-
up appraise
ना, I
करके.
will dismiss.
How bank is, my lord,
I am
working?
not going to see all these things. Not at all.
How bank is
You
going
go wherever
contrary
you
to their own my lord, guideline?
No, no.
They are guided by
No,
RBI.
no, God. They
They
will go
cannot,
by
my lord.
case to
if-
case basis.
My lord,
I can't.
my humble submission, my
Well,
lord.
tomorrow the bank will lose
Yes.
20 crore. Will you
lord,
will be responsible for that?
My lord,
Or the
or
court
my
responsible?
3% share can protect the.
Sir, I'm least bothered.
So
about
he
your
is
3%.
coming up with a better proposal.
I am not. If the bank is not interested, I cannot compel the bank.
My lord, then bank is bent upon.
Sir,
Bank is, my
not
lord,
interested.
my
you
lord,
are
bank
bent
is
upon-
not doing as his the right which comfort them.
Sorry.
And the.
Okay,
person-
reserve the order next order.
My lord,
Next
kindly.
order. Reserve the
Next
order.
week, next week,
Nah,
I will
yeah,
apprise,
next week.
I will file at least your lordship's
No.
kindly see,
Nothing.
the bank can do by substituting the personal liberty. So my,
That bank matter, here the bank is not interested.
ଆଜ୍ଞା ମୁଁ bank of ଜାଣିବୁ to next week ରେ ଆସୁ I will apprise.
Next week
I
will
will-
share hବ।
Next week kindly. Next week.
दे
Date
दे
ଚାରିଟା।
14 ତାରିଖ ସେଇଆ ହବ ହେଲା
ମୁଁ ଗୋଟେ ଛୋଟ-
next week ସେଇଆ same answer my answer will be same yes
Next
you
week
can't
ଆସୁ,
compel the bank to do this is not done.
But they are doing.
Your company maybe you whatever maybe your company
Well,
you
they are-
cannot compel them
they
they
are-
are dealing for the public money ଆମ ମାନଙ୍କର ପଇସା ସେ bank ରେ ଅଛି
ଆଜ୍ଞା ଅଛି
Ah,
ଆମେ ବି
bill-
ଦେଇଛୁ I am
bill-
also entrepreneur. I
Ah, bill-
bow down your lordship's view.
entrepreneur
I bow down my lordship's view. But in some cases they have done. If some viable credit worthiness person is coming.
they are doing that
Yes.
they are the best manager to decide
But it is not a monopoly. If some good credit worthy
Sir,
person is
I'm
coming.
not joining issue with you sorry you want time I'm giving
Next
time
week, no, next week, no,
जाओ।
next week.
14 तारीख जाओ लगे दे
14 ଟା ମୁଁ ଟିକେ ରହୁନି next ତା
କେବେ
22 ତାରିଖ।
ଓ 22 ତାରିଖ ଏଠି ଅଛି କିଛି ଆଇତେ ଅଛି ନା କିଛି
ହଁ interim order ଥିଲା।
କିଛି ଦେବିନି
ନା interim order ଥିଲା ଆଜ୍ଞା।
interim
ଥିଲା।
vacate କର
Interim order there.
you have to finish it no interim sorry sir why should I bank will compete no
Sorry my lord.
no
Let
I have no interim
last chance.
no no
Lordship
interim ଛାଡି
last chance.
interim
Well, last chance.
ନାଇଁ ନାଇଁ ବ୍ୟାଙ୍କ ରେ ବିଲକୁଲ interim ଦେବା କଥା ମୁଁ ଦେଇଛି that is I have committed mistake you know
Kindly.
interim ନା
Last chance your lordship.
ନାଇଁ sir ନାଇଁ ବୋଲ ନାଇଁ
ସେଇ ଦିନ sorry.
no
ଆଜ୍ଞା।
sorry sorry
I will be
That can't be
misunderstood.
done.
I will be misunderstood.
misunderstood ମୁଁ କଣ କରିବି
Sorry.
ମୁଁ beyond your ମୁଁ
Sorry.
କେସ୍ ଟା ଜାଣି ନଥିଲି ମୁଁ ଦେଇଦେଲି
Sorry. Sorry. I
ଏବେ
kindly.
କେସ୍ ଟା ଜାଣିଲେ both side କୁ ଶୁଣିଲା ପରେ interim ନେବି
Kindly sorry.
nothing doing I can't
Interim order.
no no interim if you want to argue
Sorry.
fully
Sorry,
pass the
madam.
order appropriate
I
order otherwise interim order ଦେବି
I misunderstood.
ନାଇଁ you misunderstood this is not
Sorry my lord.
sorry ଏମିତି କେସ୍ misunderstood ମୁଁ କଣ କରିବି
I humbly pray.
Sorry.
Please, last chance. Your lordship. Last chance. Last chance.
ନା ନା last 20 second ଲଗେଇଦେ ମିଶନ ଏଟା ହଟେଲ
Personal
Well,
appearance
last-
may be dismissed.
Last chance. my lord.
sir please don't
Sorry,
compare
my lord,
me
I
with
will
this.
be
I am
On that
I'm
day,
really sorry for that
I
please.
humbly, my lord, undertake. I before lordship
No.
that day will. fix
I am
it.
not going to compel the bank to just because of the advantage of the court order, the bank should be compelled to do something wrong. No. I
On
can't.
that day, I will apprise. my lord.
No, no, no.
At least
Sorry.
till that.
The matter, the interim order will be vacated, simple. आज ही शुणिबे आर्ग्यू करिवे पूरा फाइनल शुणिदेबी नहले आपण यू वांट एडजमेंट interim order will be vacant. Simple. If you want argue, complete argument.
No, I will not argue with them.
Then vice asu interim order hota the bank I can't force the bank. Sorry.
Sir, interim
Next.
order is not causing any prejudice to bank.
Sir, if it is not prejudice to them,
Not prejudice,
they will not do anything.
because these
If
are
they are not prejudiced, then why should they? Why are bother then? They will not do anything.
because I am apprehending the status of the my other company. So that is
What can I do, sir?
that company. I am not.
आपको इस हाथ में भी लड्डू, इसमें भी लड्डू, हर
Sir,
हाथ में लड्डू
tomorrow
कैसे
if
मिलेगा?
something happens, then my CIBIL score should not be.
So that is hard. How can I protect, sir?
I am a new entrepreneur. I have just started my small business. I'm a small business.
How can I?
I'm a small business.
कितने होते हैं उड़ीसा रे?
And tomorrow, if my other company is something,
No.
so
Court should not be.
I bow down. I bow down. I'll not next time. I'll not. I'll not ask for any.
No,
side.
no.
Or you let's be sorted.
Nice, sir.
At least.
Court should not be usually handled like this. No. If you want to complete the argument, I have nothing is there. You give me a short note, I'll pass the order. I reserve the order. Simple. इतने लंबे पे कौन भाई? I reserve the order. Final कर दो. Just you an appeal anywhere you can appeal.
Sir, next week रखूँ तो interim.
Next week रखुची पड़ा 22 तारीख रखी देली किंतु एटा रहइबनी. Protection रहइबनी.
I'll be.
Next item. Next.
Kindly.
Item 9.
No, don't.
Sir, kindly, I pray.
Don't force me.
I humbly pray,
No,
Lord,
no.
at least
No.
for the sake of Lord,
No.
because that
See,
is.
I don't have any problem with anybody. See, personally, I don't see anybody. I see the larger interest of the society.
No,
not
Milord,
the
but
personal.
interim order,
Lawyer
why?
may come, lawyer may
See,
go, but
Milord.
the bank, money, these issues, they should not
Milord.
be utilized as a
My lord,
handle.
all with bona fideness can say, I have never been a defaulter, though I am a
Maybe,
business.
sir, that is for the bank.
And I am doing business, also taking
no,
loan from SBI.
I am not doing anything.
I have, Milord, why the company Magnum?
That thing you tell before the bank, I am not saying.
Milord, once the Magnum will be, Milord, any problem, that is a interim order by my lord protected, not against the bank.
What can I do?
Only because if Magnum
So,
will be defaulted.
ସବୁ ଏ କଣ ଇଏ
काले से Magnum again जदि loan default हबा ताले मो सिविल स्कोर टा प्रोटेक्ट करतला हबो. My lord was
order
protected.
called Jandu order. ये Jandu order pass करिवी.
नहीं again से काले से बैंक से
against ଆପଣ ଯୋଉ question question I have to pass a Jandu order. You know Jandu order.
प्रोटेक्शन देथिले आगे.
ना protection कौन
काहे कि सिविल स्कोर टा काले
ମୁଁ
खराब.
କିଛି କରିବିନି sir, sorry. ଏମିତି ହବନି. This is not done. Beyond a point, you have to also know how to stop. Where to stop. This is not. Next
Item number 9.
Next item.
Please, Lord Signal. This is a matter relating to disagreement of Anganwadi helper matter. In last order by this Honorable Court matter on 13/12/2021, this order Honorable Court has directed to submit the full order of the lower court matter that has been I am submitted matter. That has been filed matter.
So this is that order sheet, court of sub collector.
My lord,
This one.
my lord,
So you are for the petitioner.
my lord.
What happened? You are the highest scorer. You are the highest scorer. You are the highest scorer.
My-
I'm asking, are you the highest scorer? ଆପଣ ଅଧିକ ମାର୍କ ଥିଲା କି ଏବେ ବୁଝିପାରିଲେ?
During work matter they have discussed.
ହଁ
During working matter or working periods they have discussed me.
ହଁ ଦି ଜଣଙ୍କ କ୍ୟାଣ୍ଡିଡେଟ୍ ଭିତରେ କାହାର ସ୍କୋର ହାୟର ଥିଲା ଆପଣଙ୍କର ନା ତାଙ୍କର?
No, on the allegation of supervisor matter they have
ଏ
discussed.
ଭାଇ ମୋ କଥାଟା ବୁଝି ପାରନ୍ତିନି ଆପଣ? ମୁଁ ପଚାରିଲି ଆପଣଙ୍କ ଭିତରେ ଆଉ ଯୋଉ କ୍ୟାଣ୍ଡିଡେଟ୍ ଯାହାକୁ ଦେଇଛନ୍ତି ତା ଭିତରେ କାହାର
No matter that is not the matter matter. Actual matter is while working matter on the
କାହିଁକି ଆପଣ କାଢିଲେ?
sir,
ଓ
on
ଆଚ୍ଛା ମାନେ
that is
ଇଏ ଉପରେ ସିଲେକ୍ସନ ଉପରେ ନୁହେଁ?
no matter.
ଆଇ ଏମ୍ ସୋ ସରି ତ ଆପଣ କଣ ପାଇଁ କାଢିଲେ? କିଛି ତ ରିଜନ ଥିବ ନା?
On the allegation of supervisor matter that she has been neglecting the duty. That's why.
Rightly they disengage you. What can I do?
Thereafter, this honorable court has directed to file appeal. And appeal matter, the appellate court had you did not consider matter.
ଆପଣ କଣ କଲେ? କଣ କରୁଥିଲେ? ମାନେ what are the allegation against you?
That we are not. I am not obeying their order. No, at the time of cooking, I am not at the hall, my lord. Cooking hall, at the time of cooking, my lord, I have neglected.
କୁକିଂ ହଲ୍ ରେ ଆପଣ ନଥିଲେ ପିମ୍ପୁଡି ଜନ୍ଦା ଝିଟିପିଟି ସବୁ ପଡିକି ଯାହା ହେଲେ ପିଲା ଖାଇକି ମରିବେ ପଛେ ଆପଣ ଚିନ୍ତା ନାହିଁ।
But my lord, not falsely, my lord, they are on revengeful, my lord, attitude, my lord. She has,
अरे सब तो ऐसे बोलते हैं जो भी when we are just found not doing your work properly, then you will say very revengeful attitude. This is not done. ଆପଣ କାମ କରିବେନି ଆଉ ପଡେ ଆପଣଙ୍କୁ ଆକ୍ସନ ନେଲେ କହିବେ ରିଭେଞ୍ଜଫୁଲ ଆଟିଟ୍ୟୁଡ କାହିଁକି ରିଭେଞ୍ଜଫୁଲ
I filed appeal, my lord.
ଅପିଲ ଅପିଲ ତ ଶୁଣିଲାନି ଆପଣଙ୍କ କଥା ନା ତ ମୁଁ ବି ଶୁଣିବିନି।
My prayer to set aside the order. My prayer to set aside the order.
କାହିଁକି ସାଟିସ୍ଫାଇଡ୍ କରି କୁହନ୍ତୁ ମତେ ସାଟିସ୍ଫାଇ କରନ୍ତୁ ଆପଣ କଣ ପାଇଁ କରିବି ତ କହିବେ ଖାଲି ଆପଣ କହିଦେଲେ ସାଟିସ୍ଫାଇ କରିବି ନା କଣ ପାଇଁ କରନ୍ତୁ।
May pray for to issue notice, my lord, at least to take
ଇସ୍ୟୁ
instruction.
ନୋଟିସ୍ ପୂର୍ବରୁ ଆପଣ ମତେ ସାଟିସ୍ଫାଇ କରନ୍ତୁ କାହିଁକି ମୁଁ ନୋଟିସ୍ ଇସ୍ୟୁ କରିବି ଆପଣ କିଛି କେସ୍ ଟା ଥିଲେ ସେ ନୋଟିସ୍ ଇସ୍ୟୁ କରି କାହିଁ ଅନନେସେସାରୀ ଟାଇମ୍ ୱେଷ୍ଟ କରିବି।
No, she is jobless, my lord. She is poor lady.
अरे सर ये तो लीगल आर्गुमेंट नहीं है लानी लीगल आर्गुमेंट है करूँ तो ये जॉबलेस है लीगल आर्गुमेंट।
Under natural justice.
अरे नेचुरल जस्टिस कौन काम करेंगे नहीं और नेचुरल जस्टिस करे ऐसे छोड़ो। लिखनी सिंपली लगा इश्यू नोटिस टू ओपन कॉन्टेस्ट समस्त को दियंतु कॉपी चारटा कॉपी दियंतु चारटा कॉपी दियंतु लिस्ट मैटर ऑन 11th सॉरी 5th October आस है
Item 10.
5th October
Item 10.
you are continuing there you are continuing there
Here. Now I am not. I am disengaged, man.
हां आसु दे नोटिस
Obliged.
एबे की करछि
Another person is engaged.
another person की
I have no interest.
First time ଆସିଲେ ତାଙ୍କର
another person की ଆପଣ ତ ଜାଣିଥିବେ ନା
I have no interest on detail instruction. Some
କଣ ଅଧା ଅଧା ଆପଣ କ୍ଲାଏଣ୍ଟ ତ ପଚାରନ୍ତି ଆଜ୍ଞା କିଏ ରହୁଛି କାଢିଲା ପରେ କାହାକୁ ଦେଇଛନ୍ତି 2 ନମ୍ବର କୁ କି 3 ନମ୍ବର କୁ ପଚାରିବେନି ଆପଣ ମୁଁ ଆପଣଙ୍କୁ ଷ୍ଟେ ଦେବି ବୋଲି ଭାବୁଛି ଆପଣଙ୍କୁ ପଚାରୁଛି ଆପଣ ଷ୍ଟେ ବି ନେବାର ଇଣ୍ଟରେଷ୍ଟ ନୁହେଁ ଜାଣନ୍ତୁ ଚାକିରି ଯଦି କରୁଥାନ୍ତେ ମୁଁ ଷ୍ଟେଟେ ଦେଇଥାନ୍ତି
taking the instruction.
ଆଉ ସେ ଶୁଣାବନି ଜାଣନ୍ତୁ ବାଇଶ ଆସିବେ ଆଉ ଆପଣ ହିସାବ କରିକି ଆସିବେ ନା ଆଉ ଯଦି କଣ୍ଟିନ୍ୟୁ କରିଥାନ୍ତି ତ କାଢି ଦେଇଥିଲେ ମୁଁ ଷ୍ଟେ ଦେଇଥାନ୍ତି ସେଥିପାଇଁ ପଚାରିଲି ମାନେ ଷ୍ଟେ ମୁଁ ପଚାରୁଛି ଆପଣ ଷ୍ଟେ ପାଇଁ କହୁନାହାନ୍ତି
14/2/2020
ଏବେ କିଏ କରୁଛି ସେଠି
14/2/2020 ରେ ଅର୍ଡର ହେଇଥିଲା ଫର ପ୍ରେସ ଆଡଭର୍ଟାଇଜମେଣ୍ଟ ଆଉ କିଏ କରୁଥିବ
ପ୍ରେସ୍ ଆଡଭର୍ଟାଇଜମେଣ୍ଟ ହଉ ପାର୍ଟିସିପେଟ କରନ୍ତୁ ଆପଣ କ୍ଲାଏଣ୍ଟ କୁ କହି ଦିଅନ୍ତୁ ପାର୍ଟିସିପେଟ କରନ୍ତୁ
ହେଇଯିବଣି because this order is 14/2/2020 we are in 2020 ହେଇଯିବଣି I'll take instructions who is working there right
take notice take instruction whatever see that next
Item number 10.
Now, on behalf of Shakti Prasad Das, I am submitting the OSBC has not released the death fund and other pensionary benefits of the father of the
sir ଆପଣ ତ ଘରେ ଅଛନ୍ତି ମୋର ଗୋଟେ କାଢି ଦେଲା ହବନି ଘରେ ତ ଅଛନ୍ତି ନା ଆପଣ କୋଉଠି ଘରେ ଅଛନ୍ତି ହଁ ଚେମ୍ବର ଆପଣ
ଘରେ ଅଛି ଯେ my habit is to
ଶୁଭୁନି ଆପଣଙ୍କ କଥା ଟିକେ କାଢି ଦିଅନ୍ତୁ ଏଟା ହଁ ଏବେ କୁହନ୍ତୁ
say OSB has not released the petitioner's father's death fund and other pensionary benefits on the ground that in 2016 the deceased has not updated his profile data.
Updated his profile data मैंने
give all the papers of education.
बार काउंसिल तो सेबले कहूची periodically आपण जे प्रोफाइल डाटा अपडेट न करियो बोले आपण लॉयर बोली किन जाना पड़ियो आपण लॉयर कि नॉन लॉयर किन जानिबे खाली जस्ट रजिस्ट्रेशन कर दिकरे आपण ट्रक बस जाय छै चलेबे जा ए करबे तापर जे डेथ हले आसी पैसा दियो बोले होबे
no
लॉयर मन के पैसा अवेलेबल ना
other documents has given district judge has given he was working and he has been practicing
अपडेट न कले सर केनती हबो आपण बार काउंसिल रो डाटा रे अपडेट करे पड़ियो ना
but now
might be saying anything
he died in 92 age so there is no possible at the age of 87 who was illness now somehow rather it has to be decided by the Bar Council of India or Bar Council of India says if he is above 90 his case should have been done by 2021 itself
Sorry,
So
21?
90 years, they are taking all India information. So I pray let the notice go. What they say now elected body has also come.
Okay, okay. The petitioner seeks direction from this court to release the death cum welfare fund and other funds, etc. of his late father who was practicing as an advocate for about 61 years and was a senior member of the Ganjam Bar Association. He was also a public prosecutor at Barampur for a substantive period of his professional career. Hence, he is legitimately entitled to get the death cum welfare fund. However, on the ground of defect of non-updation of his profile data in the year 2015-16, his benefit is not granted. Being a very senior lawyer and was quite immobile during the last part of his life, he could not update the information with the bar council. That should not impede the release of fund to the petition. Therefore, the delay in releasing the fund by the opposite party defeats the purpose of the fund maintained for that said purpose. Issue notice to since the fund has not been released for such a long time, the petitioner is constrained to approach this court. Issue notice to OP number 1 and 2.
Speed post.
By speed post. This is the matter on October 11.
My lord.
Next.
Item 11.
11.
Please, my lords. Your my lord, the notification of Tamil Nadu government was wanting. I have.
Sir, you got the notification?
I could not get it.
Cannot get.
I am trying. I
Agar pagar Tamil da achi.
ମୋ ପାଖରେ ଯୋଉଟା ଥିଲା ସେଣ୍ଟ୍ରାଲ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ର ଦେଇ ଦେଇଛି ସେଟା
ନାଇଁ ତାମିଲ ଟା ଅଛି
ନାଇଁ ତାମିଲ
ତାମିଲ ଟା ଆଣନ୍ତୁ ହେଲେ ମୁଁ ହେଲେ ତାମିଲ କରିଦେବି ଆପଣ ଇଂଲିଶ କରିଦେବି ତାମିଲ ଟା ଆପଣ
ମୁଁ ଦେଖୁଛି
AI I can translate ହେଲା ତାମିଲ କୁ ଇଂଲିଶ ରେ କରିଦେବା ଆପଣ ଦିଅନ୍ତୁ ତାମିଲ ଟା କେହି ଦିଅନ୍ତୁ
ନାଇଁ ଏବେ ନାଇଁ ମୋ ପାଖରେ
ତାମିଲ ଟା ବି ଦେବେ ଟିକେ ମୁଁ ଟ୍ରାନ୍ସଲେଟ କରିବା ପାଇଁ ରେଡି ଅଛି ଆପଣ
ନା ନା ସେ whatever was available I have already submitted. So I am trying to get
ତାମିଲନାଡୁ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ର ଦେବେ ବୋଲି ସିନା ହବ ଆଉ ଆପଣ ସେଣ୍ଟ୍ରାଲ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଦେଲେ କେମିତି ସବୁ ଷ୍ଟେଟ has its own policy.
There is a direction to the state governments, but specific notification is not there. That is what you wanted.
No. You do one thing. You give me the Tamil notification or Tamil guideline. I'll get it translated for you for free. Otherwise, for translating Tamil to English, it costs 300 rupees. I used to pay when I was practicing. 300 rupees niyanti. ମୁଁ ଆପଣଙ୍କୁ free କରିଦେବି କହୁଛି.
The notification would pass.
At that time, AI was not available. Now AI is available. I am doing English to Odia translation through AI only. So I can get it done for you by taking the help of AI. ଦିଅନ୍ତୁ ଦେଲେ ମୁଁ କରିଦେବି. First give me. Find out ଆପଣ କ୍ଲାଏଣ୍ଟ କୁ କହନ୍ତୁ ସେ ତାମିଲନାଡୁର ଗାଇଡଲାଇନ ଟା ଦେଇଦଉ ତାମିଲନାଡୁ ଗାଇଡଲାଇନ ମୁଁ ତାମିଲନାଡୁ ଗଭର୍ଣ୍ଣମେଣ୍ଟ କୁ ନୋଟିସ ଇସ୍ୟୁ କରିବି ନା ଆଉ କେମିତି କରିବି
ଯିଏ ଆଜ୍ଞା କାମ କରୁଥିଲା ସେ ହିଁ ମରିଯାଇଛି ତେଣୁ ମୁଁ I am just trying to get it.
କିଏ ତ ଥିବେ ନା ତା ଫ୍ୟାମିଲିରେ
I am trying to get it.
କିଏ କ୍ଲେମ କରୁଛି ଯିଏ କ୍ଲେମ କରୁଛି ସେ କ୍ଲେମେଣ୍ଟ ଟା ତାର ଇଣ୍ଟରେଷ୍ଟ ନାହିଁ ସିଏ ତ ପଇସା ପାଇବ ଖାଲି ଆଉ ବାକି କିଛି ହେଲ୍ପ କରିବେନି ଆପଣଙ୍କୁ
ତାର ୱାଇଫ ପିଲାମାନେ କରୁଛନ୍ତି
ତ ଟିକେ ହେଲ୍ପ କରନ୍ତୁ ତାକୁ ନହେଲେ ଗାଇଡଲାଇନ ଟା ଦେଇ କରନ୍ତୁ ଯଦି ଗାଇଡଲାଇନ ନେଟ ମିଳିଯିବା କଥା
ମିଳୁନି ସେ କେବଳ ତାଙ୍କର chief minister relief fund is only available, nothing else. That is limit is 2 lakhs. And the chief minister relief fund cannot be claimed unless government
You try,
notification.
you try and give this Tamil version, chalega. I'll get it translated for you. So I'm granting you another 15 days. Just try it.
2 weeks.
So unless 2 weeks. Unless I get the guideline, I can't pass on. That's the problem. Okay. Let's the matter on 18 করছি 18 ରେ ଆପଣ କୋଉଠି ବି ଆଣନ୍ତୁ ଆଉ ମତେ ଦିଅନ୍ତୁ ତାମିଲ ଫର୍ମ ଚଳେगा I will get it translated.
ତାମିଲ ଯାହା ଥିଲା ମୁଁ ଇଂଲିଶ କରିଦେଇଛି ତାକୁ ସେ ଏଫଆଇଆର ଟା ଆଉ ଯୋଉ
ନା ନା ସେଇଟା ନୁହେଁ ଗାଇଡଲାଇନ
ଗାଇଡଲାଇନ
ତାଙ୍କ ଷ୍ଟେଟ ର ଗାଇଡଲାଇନ ଆମେ ଜାଣିନୁ ନା ଆମ ଓଡିଶାର ଗାଇଡଲାଇନ ମୁଁ ଜାଣିଛି ଓକେ
ନା ସେଇଟା ବି ଦେଇଦେଇଛି ଓଡିଶା ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଟା ଦେଇଦେଇଛି
ଓଡିଶା ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଦରକାର ନାହିଁ ନା ଆମେ ତାମିଲନାଡୁ ସେଠି ଏକ୍ସପାୟାର କରିଛି ତାଙ୍କର ରୁଲ ହବ ନା ଓଡିଶା ରୁଲ ହବ the rule governing Tamil Nadu state will be governed that will govern you not Odisha rule.
They are providing the funds out of the chief minister relief fund.
That is different fund. That is a different fund.
So I have got
Ex-gratia is another fund. That is another fund. Ex-gratia upon darkar na seita. Take some source from any source you get it. Tamil ta anandu chodibo hala. Next.
Item 12.
May I please, Lords? My lord, here your lordship can have a glance to page 13, my lord, of my writ petition 24601. That is a circulation dated 20th of October 2022.
Which pages?
Page 13, 13.
My lord, before my learned friend starts arguing, if your lordship permits me and both the sides permit me, there should be a logical end to any problem.
Yes.
That I can propose, if your lordship accepts.
That is what we are for.
Subject to your lordship's acceptance.
That circulation is challenge in the second writ petition.
You are for?
I am in the second writ petitioners.
Writ petitioner.
I have challenged that
Mr.
circulation.
Das, you are for the.
I am for the central government. First writ application is a product of the second writ application.
I am the second question for the bank. We don't understand why we are being made up.
Bank is no.
Ines, every day she comes and sits for hours together to.
No, I have not met. I have not met.
Added to the party because they are going to release the society funds. So that
But the bank, why should bank?
so because they are going to release the funds, so that's why he has added.
Unless the amount is decided who will be paid, then where is the question now?
Just wait. It will be disposed of. Lordship will dispose of this writ petition as per
Okay.
suggestions.
Okay, just you want to say.
My lord, this is regarding election of office bearers of an association.
Yes.
A zonal committee. Actually, as a matter of fact, against somebody, one office bearer, there was a no confidence motion. After that no confidence motion, an ad hoc body was created. That is after this no confidence.
My lord, here the issue is very simple. Issue is very simple. I am petitioner for the first writ petition, the leading lead petitioner. I am for the petitioner.
If my writ petition will be decided, then everything will be decided.
No, my lord. That the second writ petition I have filed because the second writ petition is challenged.
As a petition, let me.
I am in second because that circulation itself.
You focus on the point, man.
My lord, under page 13, a circulation was made forming an ad hoc zonal executive committee of the Railway Employees Association.
So you are what?
I am of that both petitioners are the president and secretary of the ad hoc committee. That circulation was made. That circulation has been challenged by my learned friend in the connected writ petition.
You are one of the members.
Yes, I have challenged.
You are one of the members.
Yes.
No, I am
In
not.
that writ
I am
petition,
original elected body members.
Arey bhai, elected was ada kude aila puni.
What happened?
term
what
was
happened,
expired.
That is the key. What happened? One of the secretary has been removed from the secretary by a non-confidence motion.
That's what I was saying.
And I have made a resolution and written to the railway board to circulate that resolutions. They have not circulated. Thereafter, I filed a writ petition under Annexure 10. This I had ordered the 10 millers, Annexure 10 millers
ଆପଣ ଆପଣ ଚିପଡ଼ି ବସନ୍ତୁ ଆଉ ସେ ଏଡା
ନାଇଁ, ନାଇଁ, ମୁଁ ସେଇଟା
ଆପଣ
କହୁଛି।
ମୁଁ ବୁଝିଗଲି ଆପଣ
2009, 1/10/2019, 1/10/2019, the initial circulation was made. As per the bylaw, the validity or tenure of the committee would be expiring 3 years. So 1/10/2022, the tenure of the elected committee was over. So as required under the bylaw, an ad hoc committee was formed. And that was circulated on 28th of October.
So you are the member of the ad hoc
Yes,
committee.
my responsibility as per bylaw, I will have to conduct the election. So by the time I started to I issued the notification, I received one letter that the circulation of forming the ad hoc education zonal executive committee has been kept in abeyance by showing that there was some interim order passed in WPC.
Education department ଏତେ ଦିନ ରହି ସବୁବେଳେ education ବାହାରୁଛି ପାଟି education ବାହାରୁଛି Okay.
So that department on 6/1/2023, a letter another circulation was made that the circulation dated 28th of October 2022 has been kept in abeyance because of the interim order passed in the WPC, which is before your lordship in the secondary petition. My challenge that when no interim order was passed.
Solution.
That's what I was proposing.
Solution
Election is
कौन?
to be conducted.
My lord, since no
Election
interim
is to be
conducted,
conducted,
na?
that much.
election I will have to conduct the election because the bylaw, as per bylaw, the ad hoc committee.
ଆପଣ ad hoc committee କେତେ ଦିନ ହେଲାଣି?
My lord, it was formed on
Election କେବେ ହେବା କଥା?
election 6/1/2023 ରେ ନା 5/1/23 ରେ ମୁଁ notification issue କରିଛି 6/1/23 ରେ ମତେ captain abeyance କରିଦେଲେ।
ସବୁ ଉଡେଇ ଦଉଛି election 2 ମାସ ଭିତରେ କର।
Yes.
ଆରେ କିଏ କରିବ ତମର ଛାଡ ସେ ad hoc committee କରିବ।
ad hoc committee କରିପାରିବନି
ନା ମୁଁ କହୁଛି କରିବ।
ad hoc committee illegal appointment
ନହେଲେ କାହାକୁ ଗୋଟେ ବାହାର କାହାକୁ ଗୋଟେ ଡାକିବେ ସେ କରିବ।
ଯୋଉ clause basis ରେ ad hoc committee that clause has been withdrawn, my lord.
It will be much better if you lordship fix one responsible officer to conduct the election. That will be much better.
ଏଠିକାର responsibility କିଏ ଆପଣ better କହିବେ?
Railway ର general manager କୁ ଛାଡି ଦେଇକି next
general manager କରୁ।
general manager P personnel
କରୁ।
Under his supervision.
Yes, that will be much better. That's what I was proposing from the beginning. Unnecessarily wasting time.
ad hoc body on basis of which clause has
ଛାଡନ୍ତୁ ନା ସେମାନେ ଅଫିସର କରିବ ଗଲା
ଦରକାର ତ
only annex 10 day ଦେଖ।
5/1/23 ରେ ଆମେ notification କରିଥିଲୁ 6/1/23 ରେ election କରିଥାନ୍ତୁ notice ହାଇ କୋର୍ଟ interim order ଦେଇଛନ୍ତି stay କରିଛନ୍ତି ଗୋଟେ false information ଦେଇକି ଆମକୁ ବନ୍ଦ କରି ରଖିଛନ୍ତି।
ଦେଖିବି ନାହିଁ simple ମୋ କଣ ତାଙ୍କର ଏଟା
general manager personnel general manager bracketed P ସେଇଟା personal
ନା ସିଏ ହଉଛି ସବୁ root of all evil।
general manager
honorable court କହିଲା ଆମେ body ରହିବୁ ବୋଲି complaint circulate କର
honorable court ଗଲା ମୁଁ honorable court କହୁଛି କେହି କରିବେନି ସେ କରିବ ଖତମ ଏତେ କଥା
ସେଟା ମୁଁ କହୁନି ଯେ
ଆଉ honorable court କଥା ଛାଡନ୍ତୁ
that is the best way of solution
ଟିକେ ଦେଖନ୍ତୁ order ଟା ଟିକେ
କଣ ଦେଖିକି କଣ କରିବି ଆଜ୍ଞା
ଦେଖିଲେ
ମୁଁ କିଛି ଦେଖିବାର ନାହିଁ ମୁଁ simply I am going to solution ପଛକୁ ଫେରି କଣ ଲାଭ
ଛାଡ ସେଗୁଡା କାଇଁ ଲାଭ କଣ
ଏଗୁଡା ଖାଲି ଖିଚିବା କଥା ଇଏ ଆପଣ ଗୋଟେ କଥା କହିବେ ସେ ଗୋଟେ କଥା କହିବେ ଏମିତି ଟାଇମ ୱେଷ୍ଟ କରିବି ଦେଖ within 2 months
yes ma'am
the petitioners are the petitioner is in the circulation dated 6/1/2023 BD ECOR ERS RS by the deputy chief personnel officer for the opposite part number 2 that are keeping in abeyance the circulation made earlier BD letter number ECOR personnel by by citing interim order passed by the petition filed by the open number 5 and 6 bearing the petition they were depriving the present petitioner to conduct the election of the association on the pretext of interim order passed by this court. So since the election is due, since?
Since the election was due
Election
after, after
means,
one, 1/10/2022, it was due. After 20th of October 2022, we were required to conduct the election.
Rohan
And
to Raya,
we will, 2/10/22.
2/10/22.
2/10/22. Since the election was due since 2/10/22 and the election has not yet taken place. Hence, it is imperative that the election be conducted in the earliest possible. Full stop. Considering the commission of the parties and the general manager personnel shall take steps to conduct the election within a period of 2 months from today. Anything else?
Yeah, you also may add one sentence. If he so likes, he can take the assistance of some other officer. Single officer may not be.
If he so desires, he can take the assistance of some more officers.
And
to assist.
To
assist.
till then, the notification dated 20th of October
Everything
2022. Na election পর্যন্ত ফের কমিটি রে জন কে রইবে না আমি তো আডক কমিটি রে অছু
He's the, he'll take charge everything. Don't worry.
କିଛି
ଏବେ ତ କଣ
ସେ 2 ଦିନ ରେ କରିଦେଲା ଆମର କିଛି କହିବାର ନାହିଁ କିନ୍ତୁ ଯଦି ଆଉ ଭିତର ଯାହା ଆଫେୟାର୍ସ ହବ
election ହବ ପୁଣି
ଏବେ କଣ ହବ ଏବେ କିଛି ହେବାର ନାହିଁ ସେ let him till that nothing is everything is suspense. କିଛି ନାହିଁ ତ ଏବେ ନାହିଁ ଆଉ vacuum ସବୁ already ଅଛି. ଏବେ already there is a vacuum କିଛି ନାହିଁ ସେ till the election let the vacuum.
I'll try to see that the
prevail
election
over
is
the
conducted
area.
early.
ମାସରେ କିଛି ହେଇପାରିବ
I'll try to see
ସେ
that the
vacuum
election
ଟା
is
prevail
conducted
କରୁ.
early.
ଠିକ ଅଛି
ଖତମ.
I also will try to see that the election is conducted early.
ହଁ ଠିକ ଅଛି ସେଟା
Within 2 months
Yes,
ମାସକରେ କଲେ କରୁ 15 ଦିନ କଲେ I don't
Yes,
mind.
ma'am.
Within 2 months
Yes, ma'am. In the second case, I am appearing. In the first case, my lord.
the same thing follow or not?
I
My
am
lord.
the second case.
No, your lordship, your.
I have challenged that in second case I
Appearing for the bank. OP number कितने? 9.
in second case I have challenged that there is surplus সেটা খালি লিখি
Accordingly, both the reputation disposal.
Dispose
करते हैं. ଏତିକି ତ କଥା ଛାଡ ଖାଲି
ସେକେଣ୍ଡ କେସ୍ ରେ ମୋର ହଉଛି 7/8 ପାଇଁ appearance.
ମୁଁ actually suggestion କରିଥିଲି my lord senior କୁ ଏଇ
ଆପଣ
election
ସଜେସନ ନ କରିଦେଲେ ମୁଁ ସେୟା କରିଥାନ୍ତି ପ୍ରୋବ୍ଲେମ ସଲ୍ଭ କରିବାର ଅଛି ଆଉ ଧରିକି କହୁଥିବ ଇଲେକ୍ସନ
ଭିତରକୁ ପଶିଲେ ଆହୁରି ବହୁତ ଅସୁବିଧା ହେଇଥାନ୍ତା ତମେ ଯିବା ଦରକାର ନାହିଁ ନା ହାଇ କୋର୍ଟ ଅର୍ଡର କୁ ଫର୍ଜରୀ କରି କରାହେଇଛି
court order further ହେଇଛି
yes
ଦେଖାନ୍ତୁ
yes
ଦେଖାନ୍ତୁ ନା ନା
was there any interim order was there any interim order in 3279
made allegation
was there any interim order in
RBI
हाँ
and to
okay OP number 1 may be
deleted and
I number 3 OP number 1 deleted
that the petitioner took the loan from the OP 2 and 3 to purchase the excavator, Volvo excavator, whose cost is 61,36,000, depositing 15,34,000. The finance amount is 46,02,000. And another is the breaker which has been purchased by depositing 6,01,800. Finance amount is 14,04,000. And due to COVID, he has defaulted in the 6 months. But continuously they are accepting the EMI, my lord. In the October 2022, my house has been burned due to short circuit, and also I defaulted 4 installment. Till now, the defaulted amount is 11,56,000, all total 6 months. But till that they have not intimated with regard that COVID period. They have assured that in the month of November my loan is expiring, but they will extend the loan.
the opposite party
2 and 3, Volvo Finance.
Volvo Finance
they jebana deychandi Volvo say Tamkari Finance. It's a machinery company, they are itself financing.
NBFC
And I am ready to paying the EMI along with
notice we issued after that we are ready
they have not seized my machine.
okay so issue notice to 1 2 3 oh sorry 2 3 not 1 1 and 2 2 1 to delete Volvo Finance is the local branch, sir.
Now,
Yeah.
one I have adopted, that is the collecting agency who is in the Calcutta, my lord. That has been added in that IA.
But here local nahi ki.
Local nahi, tankar only zonal रे अछि, West Bengal, Calcutta रे.
एठी की आपण Volvo Finance आइला की
से गोटे लोक बसछि से कालकाटा रु सेही फाइनांस करूछि
से
सेही
आछि आपण एठू मार्केटिंग शॉप.
आगे तार मो OP1 करछि ताको
आपण कालकाटा वाला के देखि नांदी.
हां OP1 ताको एजित्रे करछि से जो आईए रे करछि RBI भी deleted and he may be added as an party.
ठीक है. 1 OP1 करो आगे 2 3 दरकार नहीं.
आगे 2 3 is the finance.
एटा तो
1 is the collecting agent.
2 3 पर 1 2 3. You serve through registered post.
Through registered. Not to
So
seize.
you are
my-
basically
not to seize the machine, my lord, till then.
Hmm?
No, I have filed the IA for interim order, not to seize till then, till their appearance.
list matter on 27th. No coercive action till then.
Obligation.
Next.
Item 17. 3 PM.
14, 16, my item is 16 also.
Item 17, 3 PM.
Oh.
16 आउट सर जा 17 को एबे हम सीरियल लिखित कर
एबे 14 चलिए नेक्स्ट 14
14 ए जा सीरियल ले अब 2 3 आउट 14
Milord, this case was day before yesterday, Milord, and I promised to solve the
किलो कौन
151 किलो जे surrender certificate टा दे
केते किलो
151
Surrender
custody
कले?
code 2020 Milord.
Surrender कले?
20
सरेंडर कर ले
Yes, Milord.
हां फिर
Milord, से surrender copy टा दउचे. This is the Xerox copy, Milord, and
151 kg
yes, Milord.
only
Milord.
you are from inside custody
Local 16/8/20 रो अछि.
16 8
आज्ञा.
you are now you're agitating on this bail only
Yes, Milord.
bail
हाँ, bail पाई.
pressing the bail is okay granted next
Obliged.
आगे जी कवर vehemently opposed vehemently opposed but did not but concede to the fact that he has been in custody since
16/8/20
hala okay granted next
Item 15.
15
No, this matter may be taken up 1 week after. My lord, he was on interim bail for a period of 3 months. And your lordship may call for a report.
he not surrender
Surrender certificate दवा का पत्र.
देना दी
That report, the instruction I don't have. Your lordship may call for a report.
केबे surrender
दबो, he is from Punjab.
Hmm?
He is from Punjab.
Lordship may keep it to next week. Your lordship may
surrender केबे कर फेसले कौन सब जान छे जानना नहीं you know not take call your senior डाकंदू
password को रखना I will call.
हां पासवर्ड कर दो जी आसन डाकंदू नहीं गया केबे I want to know next
Item 16.
नले एनवीडब्ल्यू इश्यू करबी सरेंडर करना थी पंजाब रु धरी आसबा पंजाब पुलिस बाड़े बाड़े आनबा पर पंजाब पुलिस दया माया देखा इसका गोड़ा हाथ भांगी पड़े जाएगा next
Lordship, the petitioner in fact is suffering from paralysis after retirement. So he is
Oh,
unable to come and to
Item
file a
16.
rejoinder. 16, your lordship.
हां
He is unable to come and to file a rejoinder. If your lordship permit me, I can argue taking consideration into the original application and also the counter. Because he
gender is required sir you whatever you have given whatever they have filed if anything to
only, my lord, what has happened is that he was transferred in the year 2009. Your
what
lordship,
is the issue main issue what
main issue is, my lord, after he was transferred, that was
at Malik Kendulip division to both
Kendulip division. Yes,
तापरे कौन ला
that was that was status was passed by the state administrative tribunal, thereafter rejected. This honorable court interfered and stayed the transfer order. In the meantime, my lord, he retired. He was not relieved.
now what is the issue
Now, my lord, the pension has not been given on the ground that he was relieved. But in fact, he was not relieved.
Departmental proceeding is pending. He was absent for
No,
3 years.
no, that is not absent. That is by virtue of the order passed by this honorable court. He was not
Sir,
absent. He
by
had just,
virtue of the order passed with this honorable court, you did not join the service.
I joined. Annexure
Then
7.
how can they say that not available?
Your
for
Lordship may
reason?
kindly see, he have passed the order. Your Lordship may kindly see Annexure 7. Pursuant to the order passed by the Honorable Court, I joined.
Sir, ଆପଣ ଏଇ ଯୋଉ transfer ହେଲା ପରେ ଆପଣ continue କଲେ ସେଇ ଜାଗାରେ
ସେଇ ଜାଗାରେ
ତାପରେ
status quo
stay ହେଇଗଲା
stay ହେଇଗଲା. So this Honorable Court interfered in the matter.
ତାପରେ continue କଲେ ସେଥିପାଇଁ
ସେ
continue
ଜାଗାରେ
କଲେ।
ମୁଁ join କଲି,
ତାପରେ କଣ ହେଲା ହାଇକୋର୍ଟ ଆସିଲେ କିଏ ଆଇଲା ହାଇକୋର୍ଟ
ମୁଁ ଆସିଲି ହାଇକୋର୍ଟ.
ହାଇକୋର୍ଟ କଣ ପାଇଁ ଆଇଲେ
ହାଇକୋର୍ଟ ଆସିଲେ ଯେ ଷ୍ଟେଟ ଆଡମିନିଷ୍ଟ୍ରେଟିଭ ଟ୍ରିବ୍ୟୁନାଲ କଣ କଲା ନା ସେ ଓରିଜିନାଲ ଆପ୍ଲିକେସନ ରିଜେକ୍ଟ କରିଦେଲେ,
ମାନେ ଆପଣଙ୍କ ଟ୍ରାନ୍ସଫର
ତାକୁ ଇଣ୍ଟରଭିନ କଲେନି.
finally your transfer was effected.
It is not effected. Whenever it was not effected, I came before this Honorable.
And then this honorable court what
This
did
Honorable Court interfered in the matter, state the
ତାପରେ
transfer.
pending ଅଛି ଏଟା
No, no, ସେଟା ତ another
ସେଟା
application.
କଣ ହେଲା ତାର
Stay ହେଲା ପରେ I joined on
stay କଲା ତାପରେ final dispose ହେଇଗଲା
no, it was stayed that writ application was pending.
sir ଆଗ ପାଠ କହୁନାହାନ୍ତି
ହଁ ହଁ
stay ହେଲା
ହୁଁ
ତ stay ହେଲା ମାନେ ସେ ତାର transfer ଟା stay ହେଲା
transfer ଟା stay.
okay ତାପରେ
I joined in the before the that Hon'Ble Kenduli under Annexure 7. You Lordship may kindly see.
ଆପଣ ଏଇ ଯୋଉ ବହୁତ join କରି ଦେଇଥିଲେ
ନା ନା ମୁଁ ବୌଦ୍ଧରୁ ବିଲକୁଲ ଜଏନ୍ କରିନି.
ତ ସେଇ ଭିତରେ କେତେ ସମୟ ଗଲା
ହଁ ସେଥିରେ 2 ମାସ ପାଖାପାଖି ଯାଇଛି.
3 ବର୍ଷ ଟୋଟାଲ
ସେଥିରେ
ଆପଣଙ୍କର ଶୁଣନ୍ତୁ ଏଇ ଯୋଉ ଫାର୍ଷ୍ଟ ଯୋଉ ଟ୍ରାଇବୁନାଲ ଷ୍ଟେ କଲା କୋଉ ଡେଟ୍ ରେ ଷ୍ଟେ କଲା
You Lordship Annexure 2.
କୁହନ୍ତୁ ଡେଟ୍ କୁହନ୍ତୁ ମ
12/1/2007. That is 10/1/2007.
10/1/2007
କେନ୍ଦୁଲି
ତାପରେ ହାଇକୋର୍ଟ ଏଠି ଯୋଉ ହାଇକୋର୍ଟ ଆପଣଙ୍କର ଯୋଉ ଫାଇନାଲି ଇଏ ଗଲା ସେଟା କେବେ ହେଲା
ସେଟା ହେଲା
ହାଇକୋର୍ଟ ଯୋଉ ଆପଣଙ୍କର ଏଟା ଷ୍ଟେଟ
4/7/2007.
2007 ବड़ा ଜଲ୍ଦି ଆପଣ ପାଇଗଲେ ରିଲିଫ 3 ମାସ
Anyway, then I Annexure 7 You Lordship may I joined. They say that in between I have been relieved.
ଏଥିପାଇଁ ମୁଁ ସବୁବେଳେ ଗୋଟେ ଜିନିଷ କହେ ଆଚ୍ଛା ଆଠମଲ୍ଲିକ ବୌଦ୍ଧ ଭିତରେ ଡିଷ୍ଟାନ୍ସ କେତେ ଆପଣ ଜାଣିଛନ୍ତି କେତେ ଡିଷ୍ଟାନ୍ସ
In fact,
very less distance ୟାକୁ ଟ୍ରାନ୍ସଫର କରିକି ୟାକୁ not very far I know that
ନା ଆଠମଲ୍ଲିକରୁ ବହୁତ ଗୋଟେ ଏବେ ବ୍ରିଜ ବନିଛି ସେତେବେଳେ ନଥିଲା.
ଆଜ୍ଞା ହେଲା ବ୍ରିଜ ଗଲା ଯାହା ହେଲା ବ୍ରିଜ ଗଲା ଯାହା ବି ହେଲା ବାହାରିଲେ 400-500 କିଲୋମିଟର ସେଇ ବାଟ ମୁଁ ଯାଉଛି ମୁଁ ଜାଣିନି 400-500
ନାଇଁ ଏବେ ଗୋଟେ ବ୍ରିଜ ହେଇଛି ତା ମଝିରେ ସେଥିପାଇଁ କମ ହେଇଯାଇଛି. ସେ 2007 ବେଳକୁ କିଛି ନଥିଲା,
ରାସ୍ତା
ମଝିରେ ନଦୀ ଥିଲା.
ଘଣ୍ଟେ ଖଣ୍ଡେ ଲାଗେ
ନା
ଆଉ କେତେ ସମୟ ଲାଗୁଛି କି
ସେଟା ବୁଲିକି ଯିବାକୁ ପଡିବ 10
ଘଣ୍ଟେ
200 କିଲୋମିଟର.
କି 1.5 ଘଣ୍ଟା ଲାଗୁଛି ମୁଁ ରିସେଣ୍ଟଲି ଯାଇଛି
ନାଇଁ ଏବେ ବ୍ରିଜ ହେଇଯାଇଛି, ସେତେବେଳେ ନଥିଲା. ଏବେ ବ୍ରିଜ ସେତେବେଳେ 2007 ରେ କୋଉଠି ବ୍ରିଜ ଥିଲା
ତ ହେଲା 2007 ବ୍ରିଜ ଫାର୍ଷ୍ଟ କହିଲି ପ୍ରୋବ୍ଲେମ କୋଉଠି ଜାଣିଛନ୍ତି ଏଇ ଯୋଉ କୋର୍ଟ ଗୁଡାକ ଟ୍ରାନ୍ସଫର କେସ୍ ଇଣ୍ଟରଫିୟର କରନ୍ତି ନା ଦେयर ଇଜ ପ୍ରୋବ୍ଲେମ ଏଟା ହଉଛି ତାର
on the ground.
ଆଜ୍ଞା କାହିଁକି ଟ୍ରାନ୍ସଫର ବିଲକୁଲ ଇଣ୍ଟରଫିୟର କରିବା କଥା ନୁହେଁ
Why my lord this honorable court was
ଏନିୱେ ତାପରେ କଣ ହେଲା କୁହନ୍ତୁ
then my lord I joined under Annexure 7.
ହଁ
But they say that I have been relieved. Therefore my lord this honorable court
they say not relief means
they say that prior to joining my lord, prior to order passed by this honorable court my lord I have been relieved. They say 2/1/2007 2/1/2017.
they say ଆପଣ ଜାଣି ନାହାନ୍ତି
No, I have not been relieved.
କେମିତି
My lord, I have not been relieved. Relief order has not been issued. You Lordship may see that
ଆପଣ
date
relief order ଅଛି ଆପଣ
1/2/2007. It is not sought upon me.
ରୁହନ୍ତୁ ଆଜ୍ଞା ସର୍ଟ କେମିତି କରିବିନି
ଆଜ୍ଞା
ଆପଣ ସବୁ କହିବେ ନାହିଁ ବୋଲେ କେମିତି ହବ
ନାଇଁ on record.
ବାହାରିବ ତାଙ୍କ ଭାତରେ
ସେ ଦେଖୁନାହାନ୍ତି ସେଟା ତ ମଗା ହେଇଥିଲା.
ରିଲିଫ ଅର୍ଡର କେବେ କରିଛ
ପିଅନ ବୁକ୍ ମଗା ହେବା ପାଇଁ ଅର୍ଡର ହେଇଥିଲା ସ୍ୱତନ୍ତ୍ର. ତମେ ଦେଖା ତ ରିଲିଫ କରିଛ କେମିତି
କଥା କି ଆସିକି ଟ୍ରାଇବୁନାଲ ହାଇକୋର୍ଟ ଆସିକି ଏଇ ସବୁ ଅବସ୍ଥା ସିଧା ତ ଆପଣ ଚାକିରି କଲା ଲୋକ ଚୁପଚାପ ଚାକିରି କରିଥାନ୍ତି ତେଣୁ ହେବେ ଇଏ ଚାଲିବ କିଏ କଣ କରିବ
Your Lordship may kindly see the order dated 4/10/2011. Specifically, it is directed to the opposite parties to produce the peon book to show that whether he has been relieved or not. 4/10/2011. It is to produce the concerned peon book through which the said relief order has been communicated to the applicant.
you are what
My lord,
you are what is your position
what position?
ଆପଣ କୋଉ ପୋଷ୍ଟ ଥିଲେ
Senior clerk, Your Lordship.
Senior. ପାଇଲେ
nahi is not there in the contract.
Relief
Joining report was not accepted. His joining report was never accepted.
ସାର୍ ରିଲିଫ ରିପୋର୍ଟ ତ ଦିଅନ୍ତୁ ରିଲିଫ ଅର୍ଡରଟା ଦିଅନ୍ତୁ The journey road
The
not
relief
restricted.
from 1 to 2007, let me get that order. Then I will counter it.
Give the relief order. 17 hour relief order ଦେଇଛନ୍ତି ଜଣା ପଡିବନି। Relief order relief order ଦେଇଛନ୍ତି ଜଣା ପଡିବନି।
No. Did it come on another day? I'll ask for the relief.
So what the disciplinary procedure was against him?
For unauthorized leave of absence because he has not submitted. an
Sir,
application.
ତାର position କଣ? ସେ proceeding ର।
So proceeding, but he did not, neither did he appear, nor did he cooperate. So that proceeding is pending. The Ghora agar se did
But
not
by
receive the
virtue of the
notice
stay order, by virtue of the stay order, I am continuing at home. Your specific order is passed by this one.
You are still continuing, not.
No, I have been retired, my lord. I have been retired. My pension has not been sanctioned.
was
Nothing has
granted
been
provisional
sanctioned.
pension.
I am suffering from paralysis now.
ଆପଣଙ୍କର ଏ ଯୋଉ proceedings ରେ ଆପଣ participate କରେନି?
No, I am suffering from paralysis, your lordship.
ଏବେ ସିନା sir,
No, no, 5 ବର୍ଷ ହେଲା paralysis ପଡିଲେଣି.
President କେବେ ହେଇଥିଲା?
Proceeding is pending.
Deliberately,
since-
they have initiated proceeding
କେବେ president କେବେ?
to satisfy their ego.
ରୁହନ୍ତୁ ବା କିଏ କାହାର ego ଏବେ ଜଣା ପଡିବ ସବୁ document
ଆଜ୍ଞା, ଆଜ୍ଞା, ଦେଖୁନାହାନ୍ତି।
ଅଧା ଦେଖି
March 2009.
ହଁ?
March 2009.
2009 ରୁ ଆପଣ paralysis କେବେ ପଡିଲେ 5 ବର୍ଷ ହେଲା ପଡିଲେ କେବେ ହେଇଥିବ 19 ରେ ହେଇଥିବ 18 ରେ ହେଇଥିବ ତ 9 ବର୍ଷ ଭିତରେ ଆପଣ ସୁବିଧା ହେଲାନି କେବେ
ଆଜ୍ଞା ମୁଁ ବିଲକୁଲ ମୁଁ ତ ବର୍ତ୍ତମାନ କହିପାରୁନି କାହିଁକି ନା ସେ ପ୍ଲାନ୍ ତ କୋଅପରେଟ୍
ସେଇଆ
କରୁନି।
କୁହନ୍ତୁନି
ଆଜ୍ଞା
ଏସବୁ।
ଡିପାର୍ଟମେଣ୍ଟ ପ୍ରୋସିଡିଂ କଥା ଆମେ ଜାଣିନୁ ବିଲକୁଲ।
ଜାଣିବେନି କେମିତି ଆଜ୍ଞା ଆପଣ କୋଉ
ଶୋ
ଚନ୍ଦ୍ରମାରେ ରହନ୍ତି ଜାଣିବେନି
ଆଜ୍ଞା ଯଦି 8 ମଲ୍ଲିକରେ ମୋ ଘର 8 ମଲ୍ଲିକରେ ଅଫିସ ସେମାନେ ଶୋ କରୁନାହାନ୍ତି ମତେ କୋଉଠି ନୋଟିସ ସର୍ଭ କରିଛନ୍ତି ବୋଲି।
ତ କେମିତି କରିବେ ଘର ବନ୍ଦ କରିକି ଯାଇଛନ୍ତି ତା
ଆପଣ
ଆଗରେ ପେପର
ଆପଣ
ପବ୍ଲିକେସନ
ଜାଣିକି
ହେଲାଣି।
ହେଲେ କି କଣ କରିପାରିବ ଚେଇଁକିରି ଶୋଇଥିଲା ଲୋକ କି ଉଠି ପାରିବ
ଆଜ୍ଞା, ଘରେ ମୁଁ ଅଛି ମୁଁ ଜାଣିପାରିବିନି କଥା।
I do one thing. You give me the detail, the relief order. Right now.
नहीं, your lordship may kindly see page
Roll
55.
land consent for the petitioner is the state to file the relief order.
Your lordship may kindly see page 54 of the brief.
A peon book देखिए कौन करबी?
तो सी सॉल्व करनाहांती ସେମାନେ କହୁଛନ୍ତି it has been solved. Question is that is the crux of the case. Whether the relief order has been solved upon me or not, it is not solved.
Peon through is serve हुई.
ସେମାନେ ପିଅନ
आपन ऑफिस रे.
ଆଉ ତ ପୋଷ୍ଟାଲ ର କିଛି ନାହିଁ ନା ସେଟା ଦେଖଉଛନ୍ତି ସେ ବୁକ୍ ଟା।
Right. Same office ରେ आपन post ଯିବୁ.
No, I am just placing my counter para 4. The relief order dated 1 to 2007 was served on the petitioner in due process of law through local delivery.
Local delivery माने?
Through by hand. Through registered post.
Yeah.
And by hand.
By hand. अबे कहले by hand.
Local delivery
Same
through
office
registered post.
Same office परा. अपन सही office रे काम
No, no, he never took it. Hanging at the conspicuous place on the wall of the government residential quarter of the applicant and paper publication in the manner of memo number
आଜ୍ଞा आपण क्लाइंट बहुत बदमाश है
नहीं आज्ञा
हां आपण एते
से सेटा आपण देखु ना
आज्ञा तीन टा मोड रे एटा को मोड रे आपण
बिल्कुल से ଗୋଟେ पोस्टल रिसिप्ट देखौ नांती 1 2 रो हमको देइछंती बोली आपण पियोन बुक देखंत आज्ञा 3 टा 4 टा पियोन बुक सब थरे पोस्टल रिसिप्ट अछि
आपण को मोड रे देले को मोड रे देले
जे कहउछंती पियोन रे
local delivery registered post hanging at the conspicuous place on the wall of the government residential quarter of the applicant and paper publication in the manner of
पेपर पब्लिकेशन अछि
कोड देखौ नांती
ए रोज पेपर पब्लिकेशन अछि
24/1/2007
पेज
देखौ नांती रिलीव ऑर्डर देइछन
आपण जते कहले भी ना आपण क्लाइंट बदमाश अछि
नहीं
आपण आउ को
नहीं आज्ञा एटा भल कथा भूल जिंस आपण देखु नांती आपण एविडेंस
एते मोड रे कोडी पाइले नि
एविडेंस इज बिफोर लॉर्डशिप
तापर मोर इंपोर्टेंटली जने चाकरी करथवा एते कथा जानिबनी से के पर का घर को तरकारी बनाई से खबर पाउथबो से
आज्ञा मु जेतेबेले केस करजी तांको विरुद्ध रे सेमाने कोन डॉक्यूमेंट तयारी करे मना अछि हाई कोर्ट जेतेबेले स्टे करजी आपण देखु नांती
हाई कोर्ट स्टे कर आपण पूरा एकदम मस्ती
योर लॉर्डशिप में कंसीडर माय केस
आपण
योर लॉर्डशिप में काइंडली सी पेज 54 they have said it is given in through peon your lordship may kindly see
they are also said it is given through the latka
so the postal is
they have
the requirement
they have also stated through registered post
if it is served upon me through peon what is the requirement to latka and what is the requirement to registered post
दउ नथिले कोन हबा आज्ञा peon को
registered post स्लिप दउ नाहंती एठी देखंतु पियोन बुक रे सबुडी स्लिप लगा है जोडी पठै छी
पेपर कटिंग अछि ना
पेपर कटिंग देखौ नाहंती
paper publication I will ask the paper
जा अछि बाहर
करंतु देखबे
बाहर कर
if I will be harassed like this
one thing harass species किछ नै आपण निजे गोटे हरर harass कोन करबी आपण
no my lord that is not correct that is not correct
It is sheer harassment to the applicant.
Next.
बहुत हरान करନ୍ତି ए डिपार्टमेंट सर्विस
ସାର୍ ଏମିତି କହିଲେ ହବନି ଆପଣଙ୍କ ପାର୍ଟ ବି ଦେଖିବାକୁ ପଡେ
ଏ ଦେଖୁନାହାନ୍ତି, ସେମାନେ
ଆମେ
ଦିଅନ୍ତୁ।
ସି ବୋଥ ସାଇଡ
ଆଜ୍ଞା,
ଗୋଟେ ସାଇଡ ଦେଖିଲେ
your lordship should
ଆମେ
have-
ଜାଣିଛୁ ହ୍ୟାରେସ କରନ୍ତି
ଆଜ୍ଞା।
ସମ ଟାଇମ ଆପଣ ମାନେ ବି ହରିବୁଲ କାମ କରନ୍ତି ସେଟା ଦେଖୁନାହାନ୍ତି
On evidence, if it will be
13
seen that they actually in fact
2009 ରେ କୋଉ କାହାକି ଆଡଭାର୍ଟାଇଜ ଆପଣ ନଉଛନ୍ତି
ଆଜ୍ଞା ସେମାନେ ଟ୍ରାନ୍ସଫର କଲେ ମୁଁ ଗଲିନି।
ହେଇଥିବ କେଉ କାଗଜ କୋଉଠି କଣ ପଡିଥିବ
ଆଜ୍ଞା କ୍ୱେଶ୍ଚିନ୍ ହେଲା ସେମାନେ ଟ୍ରାନ୍ସଫର କଲେ ମୁଁ ଗଲିନି, ମୁଁ ଯେହେତୁ କୋର୍ଟରେ କେସ୍ କଲି ସେମାନେ ଏଇ ସବୁ ଜିନିଷ ତିଆରି କରିଛନ୍ତି ନା।
ଟ୍ରାନ୍ସଫର କଲେ ଆପଣ ଫାଷ୍ଟ ଯାଇଥାନ୍ତେ ବଢିଆ ହେଇଥାନ୍ତା
ଆଜ୍ଞା
ସବୁ ଏତେ କଥା
ନିୟମ କହୁଛି 2 ବର୍ଷ ଭିତରେ ଓନ୍ ଡିଷ୍ଟ୍ରିକ୍ଟ ରୁ କୁଆଡେ ଯାଆନ୍ତିନି, ସ୍ପେସିଫିକାଲି ଦିସ୍
ନିୟମ
ଅନଏବୁଲ କୋର୍ଟ
କଲେ ଯେ
this honorable court specifically given and finding that though it is 1.5 years they should not be transferred.
The man culprit is this court, right? Okay, anyway, the matter of 18 as
18 this month.
yeah. You want more?
No,
October.
no.
Next.
17.
17. 17.
Yes, ma'am. We are here.
First of all, I beg apology, but I could not remain present because of my
Sir,
personal.
I had fixed for you only. You have stated
No,
both
sir.
parties said 3 p.m. I said 3 p.m.
3 p.m. is
But
all right.
3 p.m. is the matter is fixed. It is incumbent upon the party to be present.
With due humility, my lords, we are constrained by a region, my lords. My lords will appreciate because I was a roaring practitioner, knows about the predicament of a lawyer in this state, my lords.
No, that's fine, but when I'm fixing a, you should also
I
understand. the
understand, my
position
lords,
of
I
the court
understand, but
also.
I thought
When
that
you are fixing a
like,
matter,
with
you
due
have to be
humility,
present.
with due humility, I thought that probably it will be finished up before that date, my lords, because that matter was taken up at 2
Okay.
p.m.
Okay, let's start.
PM. That is what I could not be able to remain present. I beg apology for that, my lords.
So you are for the petitioner.
I am for
He is for the
the
appellant, I am for the respondent.
appellant is the
Yeah,
housing
so
board.
Appeal under 37.
Appellant is the housing board. My lords, the case in North Cell is like this, my lords. One winner security means the respondent. They supplied the manpower, that security agency, to different divisions and subdivisions of the Odisha State Housing Board. This relate to period from 90 to 96. What happened? The divisional on divisional basis, sometimes the junior engineers, they required engagement of the security personnel. These people, they directly raise the bill to the division and subdivisions and sub-subdivisions. And that is what the dispute. Subsequently, it was found that it has become very difficult in the part of the housing board. Then housing board from 96 onwards said that yes, it should be a central agreement, and thereafter no dispute arose. Now, question is that the respondent, my lords, being claimant, raised a bill concerning supply of my lords manpower. My lords, that he quantified that claim amount 37 lakhs. My lords, that period relates to my lords 90 to 96. My lords, then, my lords, this is not self. The case is this. The housing board, my lords, fact remains, but there is no arbitration clause. But anyway, my lords, considering the request of the claimant, the housing board itself appointed the learned arbitrator. Now, the first point, my lords, so far that the appointment of the arbitrator in this case, whether arises or not, that is a different question. That is not, doesn't arise. So, to my my lords' humble submission, this contingency does not arise at all. The arbitrator has the power, rightly adjudicated the dispute. Now, question is that whether the adjudication be in consonance with law or not. In this connection, I'm only pointing out one part, my lords, taking note of all.
What is the arbitration of the award? What is it?
Award, my lords, I think LCR, my lords, that is there. LCR, LCR must be there. Because fact remains, my lords, earlier, the council was conducting the case, my lords, passed away because of suffering from blood cancer. With much difficulty, I collected all these information records and some records, not all records.
We have the record.
Records from the his wife, and thereafter I entered into.
There are very few points, sir.
I will only
simply just you.
I will only
focus on the-
concentrate. My lords have already laid down the law. I will concentrate only on that point.
Yes.
What is the our
Record Kotak.
LCR must have come.
Award ଅଛି।
award to chini LCR ta darkar habo LCR nahi.
Just for my purpose, award is not for reading now,
Yeah.
but I just for.
Everything, 72 page
Oh,
award.
that you will say, well, so I will point out, Miles. It's not that I
And
say
we
that
are-
yes,
and
you
we
are
are
not
in-
entitled to all these things, Miles. That is
Please only concentrate on the.
only very
That
thinner point.
Yeah, yes.
Because Milers have already taken note of all the decisions and laid down the law Milers that reported in 2001 ILR Cuttack I-816. This Milers decision. There Milers has boiled down the situation to a position in case of a appeal under section 37. The scope is very narrow. Unless there is an error.
There is no need to go to.
No, there
case
is
law, sir.
exactly.
There
There is
is
error.
the arbitration act
Milers
itself.
brought two exceptions.
Yeah.
One error of fact and law leading to perversity. Two things. But here in this case, I made out a case concerning error on fact. And then law malus concept concerning law leading to perversity. Error of fact malus kind of a class 2 must be pleased to malus go through the order of the unquote dated 9/12/2021.
This court?
Yes, ma'am.
Which
No,
order?
this court in the sense Hon'Ble High Court.
Which court? Which order?
Hon'Ble High Court order number 11 dated 9/12/2021.
11.
9.
What is the order? Read that order.
That is 9/12 formulated that all 4 points. The only I will limit my argument to in respect of that 4 points only, because I cannot go beyond. That is order number 11. I think of Justice Sinha.
Yes, I have gone through this.
Yes.
I've seen this.
The first ground is limitation. He refers para 2. He refers to the award and submits service of respondent were discontinued since 1997 in the year 1997. The arbitrator was appointed on 30th April 2002. As such, claim of the respondent awarded were barred by limitation. He relies on section 43 of the Arbitration Act 1996 and section 3 of the Limitation Act 1963. He also relies on
But
the
all those things must have been discussed in the arbitration award and all that, all the delay and all that.
no, well, then they will
How
not
can-
sell.
Is it not the subject matter of the?
No, man, that
this,
exactly.
No issue was,
no,
no objection was raised because limitation.
I'm coming to that.
And
The limitation means you are from from the dispute to the.
Must may submit.
date of appointment of the arbitration.
No, but may I submit. I think if my lord brother
No,
will.
no, just.
But thing is that the my lords I have already stated, my lords, I have given my written note of submission. There I have categorically stated about the period. Written note of submission? No. Yes, sir. My lords, the written note of submission might be there in the record itself.
Okay. Okay.
My humble contention, the period concerning also for that claim is concerned.
Photocopy submission at points. Here photocopy. दरकार नहीं
वो photocopy दे दूँ
गोटे शर्ट दे रहा है
आगे
for my reference not required LCR not required
photocopy दे देंगे the thing is that my lords this period relates to 90 to 96 the first so far that first point is concerned then a dispute arose in course of our hearing because it was hard sometime for some length. Well, the question is even if a limitation point is not read, issues not framed, whether the arbitrator is duty bound to answer it or not. In respect of that matters, I refer to section 43 of the Arbitration Act 1996. Then section 3 is purely a case of point of law. Then the law laid down by Honorable Supreme Court in a 3-member bench decision reported in 1996 SC 942. That judgment, my kind of a class to that judgment, I enclose it to my
judgment में देखिए जाना actual next point
written note. Take written note submission. Take जाते मुझे देइची मु आपनकर येटा. Judgment टा देइची.
सर आगे तो अपन point टा करने पचे judgment देखिए नहीं
Point ये वाला first point. First point वाला suppose the parties have not raised the point of limitation. Arbitrator is bound to consider that particular contingency even if not raised. That is the decision of Honorable Supreme Court.
Okay.
Well, that is the thing. So the decision of
96 sir 96 पर कितना
96 SC 942 paragraph 4.
ब्रिज तले कितने पानी तावरे गलानी हम की
सेटा गलानी जे but a particular point answer हैनी. I have gone through that. I'm conscious because my lords have let down but taken up all the note decisions because it is a decision reported in 2023.
So my lords have taken note of all the decision of Honorable Supreme Court. But I have gone through one after another, but I found that this particular point, even if not limitation not raised, whether the arbitrator is bound to consider or not.
Okay.
That Honorable Supreme Court has categorically stated in paragraph 4, my lords, that this is the paramount duty of the arbitrator, learned arbitrator, to consider.
Read that, which paragraph?
Paragraph 4, my lord. Judgment or copy?
Yes, paragraph 4.
Judgment copy logically.
Paragraph 4.
The diverse contentions give rise to the question whether the claim are barred by limitation, whether the claim in the contract given rise to an arbitration. Section 37(1) of the Arbitration Act 40 provides that all the provisions of the Indian Limitation Act 1908 repealed and adopted by Limitation 1963 shall apply to the arbitration that apply to the proceedings in court. Subsection 2 with the non-obstinate clause provides that a cause of action shall, for the purpose of limitation, be deemed to have been accrued in respect of any such matter at the time when it would have accrued, but for that term in the agreement. An arbitration shall be deemed to have commenced under subsection 3 when one party of the arbitration agreement serves on the other party thereto notice requiring the appointment of the arbitrator, or notice requiring appointment of the arbitrator, or where the arbitration agreement provides that the reference shall be to a person named or designated in the agreement, requiring that the deference be submitted to the person so named as or designed under section 3 of the enjoins the court to consider the question of limitation whether raised whether pleaded or not. Pleaded or not.
Next.
So here in this case, my humble contention, this period relates to 1990-96. The arbitration the arbitration proceeding commenced much after that, 2002. So all these claims the learned arbitrator could have held to be barred by limitation. Then my second point. My second point, his second that para 3. That Justice Sinha boiled down all these points. I need not go beyond that, His second argument is number of bills were not received by each client and therefore cannot be said to have been raised by the respondent. It will appear from the award that burden of proving the fact was cast on his client by the tribunal. Respondent had to prove the submission of the bills by showing receipt thereof where they acknowledged by the client. This respondent was unable to prove, but there was an award in respect of those bills in favor of it. Well, number of bills were there. But what happened during pendency of the arbitration? A committee was constituted. They verified it. The committee found, test out the bills, but wherever available. But all these bills, which have been raised, out of that, the total. Let's kindly have a glance to my paragraph 7. My written note, paragraph 7. Paragraph 7. There, I'm limiting myself. Number of bills, more than 1,000 bills, 2,000 bills. I'm not disputing that. But there was a direction that there would be joint inspection, and the joint inspection was made. Thereafter, we raised objection to that joint verification, but that was rejected by the learned arbitrator. Learned arbitrator accepts the joint inspection report, and this report clearly mentions that through 38 bills, para 4, my written note of assumption, para 4. It's page 4, para 7. In course of hearing, the appellant board raised the following points for consideration of the Honorable High Court. 1. Dispute concerning non-availability of 38 bills as referred to in para 26A of the award. There, what the learned arbitrator said, they agreed that 38 number of bills are not available. But they said that the party, the concerned claimant submitted its register requiring furnishing of the bills. But question is, all the bills are tested out. These bills were not tested out. So burden lies upon the onus lies upon them to establish that these 38 bills. I'm limiting myself. It's not that I'm saying that yes, all that whatever award has been passed, it should be quashed. Except the ground, whatever I stated, my lords, in the person concerning limitation.
Yes.
These two are 38 bills. The learned arbitrator will proceeded on a presumption that relates to an intermediate period. Means up to July is there, up to September, and August is not there, then September is there. So August must be there. There must be some bill in respect of August. Such type of panels, it is not on the basis of an adjudication. There is no proof to the extent. Suppose I am coming forward and saying that yes, I have given this. Unless that other parties says that yes, I have received it, or unless the claimant says that yes, this is the signature they have received it, this cannot be taken into consideration. That is what I say. 238 bills, the total amount awarded in respect of 238 bills must not be awarded.
Okay.
Because there is no proof in any line, my lords, to show that yes, 238 bills on any ground. What happened, my lords? Kindly visualize one thing, my lords can appreciate it. So for housing matter and all these things, then my lords, situation was they were engaging the divisional officers, junior engineers, they were requiring it to accommodate and adjust. Things happened in even 1 month, 2 months, 3 months, they were not providing any employment, what bills are being raised. Okay. And there is a sharing on all these things. That my lords are acquainted of, my lords, I knows these, all these things, so knows all contingencies, my lords, I'm not raising on that. Okay. Number of bills are there. Once you said that there must be a joint inspection was paid. Joint inspection report, I raised objection. I didn't agree with the joint inspection report because my officer was there, their persons were there. Then the learned arbitrator rejected it on the ground that no, your officers were there and in their presence bills were pressed out. And the particular report, I have enclosed to my written notes of submission, my lords. This particular report clearly says, my lords, those bills were not available and no proof that these bills have been given or no receipt is shown that these bills have been given. So the award concerning 238 bill, to my knowledge, is completely based on wrong, mistaken facts and improper appreciation of the position. Okay. Extending that. Then, my lords, my third point, I've stated all these things. I'm clipping, my lords. I'm making it very clips, my lords. Then, my lords, point number 3. His third ground is that statutory dues on employees' provident fund (EPF) were not paid by respondent in relation to service rendered to his client. His client paid on recovery proceeding initiated by the statutory authorities.
Okay. No, ESI.
EPF, na?
EPF. There is no award in EPF.
No, EPF. EPF I'm coming to that. Nil award of the coach.
Order EPF
EPF, what happened? This contingency, what happened? We were treated as a principal employer. The amount so far that EPF authority adjudicated under 7A, well, attached to our account, deducted an amount. That is to be borne by the parties, not the claimant. The learned arbitrator adjudicated the same. Said no. So far as EPF claim is concerned, the board has no role to play. But on the other hand, couldn't consider those amounts which have been paid on behalf of the claimant, and this amount ultimately could have been deducted from the total claim amount, the awarded amount. This amount has not been deducted. That is what I have stated, my lords.
So these are the 3 issues. These are the 3 issues.
I have come. Dispute concerning bill, so that is, I have stated all these, my lords. Then claim 26B Roman 2. Yes, so that is not 22. Sorry, my lords. Paragraph 13. Paragraph 12 and 13.
So how these issues have been dealt by the arbitrator?
Learned arbitrator said that yes, the board is not liable to pay any amount.
No, the first issue, how is one by one? First issue, how the arbitrator has dealt?
Never dealt with. Not dealt with at all.
Second issue.
Second issue, well, that 238 they say, I presume that if he has given the bill up to July, then given the bills are available from September, then I presume that August he must have given the bill. Okay. Might have given that bill. On that presumption, 238 bills total amount quantified for the 238 bills were awarded. Total bill there is. We say about, because we cannot now say, we stopped saying that.
These issues were raised by you
Yes,
before the
learned arbitrator.
the district court.
Yes. So all these, all
How
these,
he has dealt with those?
more or less, not in a direct language, but indirectly or directly, that has been raised.
But
I will come to that.
what is
No, that is raised. The question is not that. Question is that it is public money. We
No,
we
that's fine. The money,
we
that's
are
part fine.
concerned. Thing
We
is
have to
that,
see how things have been dealt by the district court.
well, I'll come to that. I'll kindly give me some time. So far as that EPF amount is concerned, I want a settlement that amount should be deducted from the awarded amount. Awarded amount. Then, question of interest. The learned arbitrator awarded interest. My humble contention there, my lords, that is ground number 5, paragraph 5 of the order, my lords. Then the arbitration agreement. Thereafter, his client having appointed an arbitrator, the term of reference can only be ascertained from the appointment letter. There was no term in the appointment empowering the arbitrator to adjudicate on interest. So the adjudication of interest and awarding interest at a higher rate. Interest, one, my lords, my humble contention is in higher rate. Second, there should not have been award of interest.
Okay.
So on and from the date of the award is all right. But awarding interest on and from the date of their entitlement, that claim, until the award should not have been made. But my humble contention, now my lords, I am reiterating this. My humble contention, so far EPF is concerned, the arbitrator categorically held that it is not my responsibility. So there is no award claimed by the claimant. But couldn't consider the aspect, though it was specifically raised in the written statement, paragraph number my lords, we have given a detailed calculation by written statement in paragraph number 9, page 4, paragraph number 9. Whatever amount we paid, there we claimed the EPF amount of rupees 13,03,912, which has been recovered from us. If we have no liability to pay, any recovery made through execution, treating me as a principal employer, should be borne by the claimant. This is the settled position of law, should be borne by the claimant. That amount has not been adjusted. First, my lords, this amount should have been adjusted. Second, my lords, that 238 bills, that bills which were never traced out, no proof to show that we have received it, on the basis of a presumption and allowing this amount to be paid, but the grounds raised is not sustainable. Third, man, so far that limitation is concerned, that the learned arbitrator has never dealt with at all. Fourth, my lords, the concept of that so far as the interest part, the learned arbitrator, when the reference was made, there was no specific reference to adjudicate about whether the claimant is entitled to interest or not. This is what my humble submission is on not sell matters.
Yeah.
My lords, before I start and respond to my serious grounds, I'd like to just rely upon a note I had given. I'd given a date chart. The limitation ground is absolutely misconceived. I'll just demonstrate. Page 3 of that note, I've given a date chart. The earlier we approached this honorable court. By intervention of the High Court, some amounts were released to me. Now kindly come to page 8, 23 to 99.
Page 23.
Page 3, serial number 8.
Page 3, okay. 8.
Serial 8, 23 to 99. The respondent company filed WPs seeking intervention or do not to take course against any by section directed to deposit rupees, pay 4 lakhs. On 12/5/99, Odisha State has paid me 4 lakhs. On 12/2/99, again 2 lakhs. There are next page, page 4. Out of the admitted claim of 22 lakhs, OSHB released a sum of rupees 6 lakhs, that is in 2000, in favor of the respondent, leaving a balance of rupees 16 lakhs odd and disputed amount of 36. On 1/10/2000, I requested for appointment of arbitrator. Where is the delay? There is no delay. So that is why the arbitrator did not go into the limitation part. What my learned senior says regarding 96 Supreme Court, that is correct. But there has to, factually, there has to be a delay of 3 years, more than 3 years. This is 2000 only, and 2002, they delayed in appointing the arbitrator. No, my lords, so far as limitation there goes. Now, the other aspect regarding, my lords, your lordship has recently dealt with all the judgments. This is in 19/5/23, in my case only, that state versus Gujarat. Your lordship will kindly come to page 14. Your lordship has categorically laid down the position of law and the question of interference. And after 2015 and associate builders, the scope is absolutely negligible unless there is fraud. Only when there is fraud, then only there can be. And I will demonstrate also from the award. I will give a copy that it discussed everything.
Okay.
It may be noted that the present position of law as laid down by the Supreme Court confines the supervisory role of the courts while testing the validity of an arbitration award. The Supreme Court has repeatedly reiterated in McDonald International, such and such, among others, that the 96 Act makes the provisions for supervisory roles of courts for the review of the arbiter only to ensure fairness. The intervention of the court is envisaged in a few circumstances only case of fraud or bias by the arbitral tribunals, violation of natural justice, etc. The court cannot correct errors of arbitral tribunals. It can only quash the award, leaving the parties free to begin the arbitration again if it is desired. The contours of judicial scrutiny under Section 34 of the ANC Act are limited and scope of intervention is narrow. Under Section 37 of the ANC Act, the extent of judicial scrutiny and scope of interference is further narrower. An appeal under Section 37 is like a second appeal, the first appeal being the court by way of objection under Section 34. Where there are concurrent findings of facts and law, first by the arbitral tribunal, which are then confirmed by the court while dealing with the objection under Section 34. In an appeal under Section 37, the appellate court should be very cautious, reluctant to interfere in the findings returned in the award by the arbitral tribunal and confirmed by the court under Section 34. Furthermore, it is no longer res intriga. An arbitral award may be set aside only if it is against the public policy of India. That is to say, if it is contrary to fundamental policy of Indian law, the interest of just India, or the justice or morality, or if it is patently illegal. After the apex judgment finding in Oil and Natural Gas Corporation Limited versus Western Gecko International Limited were subsequently discussed in Associate Builders Development Authority, the position of law was clarified and laid down recently by the Supreme Court in Shangyong and Construction versus NHI, wherein the court was pleased to broadly stipulate the apportionment in 4 constituents of what makes an award against the public policy. It is also generally recognized that when the arbitral tribunal has thoroughly evaluated the materials and evidence presented to them, the court, when considering objection under Section 34 of the ANC Act, does not act as a court of appeal and is not required to re-examine all of the evidence or the party's case on merit. An award made by an arbitral tribunal cannot be revoked on the ground that another viewpoint is conceivably in the High Court's eye. In these cases, the court's responsibility is to determine whether the arbitral tribunal's point of view on the relevant facts, pleadings, and evidence is a reasonable one. The court should be reluctant to intervene even if, after considering the objection under Section 34, it were determined that these 2 possible statements, assessments of the material and the arbitral had taken one route instead of the other. If the arbitral tribunal's viewpoint is reasonable, the court is not permitted to substitute its own opinion for that learned arbitrator. The same has been previously reiterated by this court in state of Orissa versus Bhagyadar Das, and more recently judgments such as that United India versus Bhubaneswar Surya Udyog. And this also is your lordship's judgment. Now, my lords, at this stage, my lord, another para, I would like to also page 21, para 37. Your lordship has discussed everything, all the judgment. The Supreme page 21, para 37. Yes. Your lordship got that?
Yes.
The Supreme Court in PR SAS Shares and Stockbroker Private Limited for the BHS Securities has held that court does not sit in appeal over the award of an arbitrator by reassessing or reappreciating the evidence. An award can be challenged only on the grounds mentioned in Section 34(2) of the Act, and in absence of any such ground, it is not possible to re-examine the facts to find out whether a different decision could have been arrived at. This view was reiterated by the High Court of Delhi in Messrs. Pragya Electronics, Cosmopolitis,
and the apex court in Swan Gold Mining versus Hindustan Copper Limited. In light of the aforesaid fact, the presence of the so, my lords, here, your lordship will now come to the impugned order. Whether the 34K court, while dealing, whether he has dealt with his objections or not. Your lordship got the impugned order.
Yes.
District Judge, 17th May 2011. Page 8 of that impugned order.
Not opening.
Original.
No, no. Hang on. There's some problem. So, this is the- Yes. Yes.
Page 8. Para 7. But they raised 3 grounds there. One is that they could not appoint a lawyer, but their officer conducted. To that para 7, the learned arbitrator has stated in details all the circumstances covering this allegation. While deciding the different claims, the learned arbitrator has made specific reference to the fact and that the petitioner has not proved certain facts alleged by it by leading appropriate evidence. It is therefore to be, petitioner here is the appellant.
Yes.
It is therefore to be considered whether sufficient opportunity was not given to the petitioner or in spite of such opportunity being given, the petitioner failed to avail it. The learned arbitrator had narrated the proceedings stage by stage by indicating the appearance of parties and steps taken by them on different dates. The arbitrator was appointed by the petitioner pending finalization of OJC number in the Hon'Ble High Court of Orissa. The arbitrator was requested to arbitrate as early as possible. On 10/6/2002, the petitioner entered appearance before the arbitrator in response to the notice of arbitration issued to the party. The petitioner entered through its law officer and audit officer were heard on procedural matters, including fees and expenditure. In para 3 to 6 of the award, the arbitrator has pointed out that sufficient adjournments were granted to the petitioner wherever necessary, but the petitioner showed lack of diligence at all levels. The allegation that the petitioner is not allowed to engage a lawyer, but was compelled to depend upon the service of law officer alone does not appear correct. On a plain reading of the award, it transpires that the petitioner was not able to present his case due to time not being granted by the learned arbitrator, but other reasons which the petitioner could only explain. Therefore, the contention that the petitioner was not able to present its case due to incapacity as stated above cannot be accepted. It dealt with it. Now the question here is one. Question is whether a advocate is required to be engaged in an arbitration. My submission to this is an arbitration, the Advocates Act does not apply. Correct. So they are insisting on that I was not allowed to engage an advocate cannot be a ground at all. And they were fairly represented by its law officer, who is a law-knowing person, and another officer.
Alternative dispute resolution.
Yes.
It's not away from the formal court system.
I think I agree with that proposition.
Yeah. Yes,
Now, the
right.
next ground, important ground is that certain claims which were time-barred were not isolated, and the award was being passed on such time-barred claims which is illegal. The plea of opposite party was that this question of limitation was never raised before the learned arbitrator and therefore cannot be raised here for the first time. The specific case of opposite party is that no part of claim. I will not get into this because I have demonstrated that is within limitation. In 2000 only, I had filed the 21 application.
Okay.
Now, para 8 is the third. It was next considered that during pendency of proceeding, a petition was filed before the learned arbitrator for termination of the proceeding on the ground that there was no arbitration clause in the agreement, that the arbiter was not appointed by the Honorable Chief Justice, and 2 writ petitions were pending before the Honorable High Court. Assigning sufficient reasons, the learned arbitrator rejected the petition. Instead of challenging the order rejection at that stage, the petitioner participated in the arbitration proceedings. Therefore, learned counsel for the opposite party has rightly contended that the rejection of the set was not illegal and not be available to ground for setting aside ultimately caused by him. As regards the other contentions raised by the petitioner, the learned arbitrator has answered all questions in the award by assigning good reason.
Yes.
It is not a case that all my claims have been allowed. Part of it is allowed. Many have been rejected. Now he deals with this. He has explained why and to what extent he relied on the joint verification report and to what extent he examined the correctness of the report. He has also given reasons for rejecting the counterclaim after taking into consideration joint verification report regarding excess payment by the petitioner as claimed. In order to differ from the views and conclusions of the learned arbitrator, I have to reappreciate the materials and the evidence before both independently. So he says it is not permissible. This is not permissible law since this is not a court of appeal. There is no patent illegality, perversity, absurdity in the appreciation of the materials, and the conclusion reached by the learned arbitrator. Therefore, there is no scope of interference that rejects.
Yeah.
Now, my lords, my humble submission is that here they have not made out any ground under 34(2). So, accordingly, 34 has been rejected. Now, the rejection order of the 34 has to be evaluated in this appeal. So, in my submissions, my lord, the grounds or the on the grounds on which they have rejected the 34 application, because he had to go, what the petitioner or the appellant had made grounds was to go into the evidence and reappreciate, which is not permissible. According to rightly, he has dismissed it.
Okay. Now, my lords, I will reply. My turn of reply.
Please.
Very short.
Yes.
My humble contention.
Actually, to be very frank, 37 requires this much time. It's not requires this time because
No,
you have to have to reappreciate.
No, my lords, that is exactly. Sometimes, my lords, what we are doing is we are consuming more time in respect to appreciation of facts. I'm not there at all. I'm conscious of my position and my limitation.
I have a canchi, so I cut. So that's
See, that's all right, man. That is also fair and good. Well, fact remains, I don't know whether my learned friend.
But one thing in my order, I put everything.
That is what my lords. It shows that my lords again goes.
Even because see, many things are there.
It itself indicates that my lords again goes through all the details and everything, and thereafter my lords.
Asking for that.
Thereafter.
Tomorrow
I read everything.
Thereafter, my lords.
Unnecessary reading everything.
My lords are doing a lot of labor in the house, my lords. That is what I understood after going through the judgments.
Because the arbitration things are not. Time may be consuming less here, but while writing, you have to put.
One has to think 10 times.
Transactional history. You must
Right, my lords. After going through. I didn't come with all these documents, judgments of the Honorable Supreme Court, because my lords have dealt with all the judgment. I didn't know that my learned friend has referred to and relied upon that judgment and argued that. I relied upon.
I've covered so many.
I rely upon my lord's judgment. Not that I'm.
There are two. One is he argued. The other is the Surya Udyog.
Yes. That insurance company.
Yes.
No, that is Mahanadi Kolfi.
One is upheld by Supreme Court also. The Surya Udyog.
Oh,
yes,
that.
This is so that I've covered everything.
Yes, that
the latest.
No, here, that is latest one, but here also my lords have not differed. My lords, the consistent view. I found that it is consistent view of my lords. That is, I refer to my lords 2001 ILR, my lords. Probably that I have not gone through, my lords. Not probably, I have not gone through at all. Probably it has not been reported. I am referring to 2023 1 ILR Cuttack 1816. My lords, this one. There, my lords, in paragraph number 32 to 37.
Which case?
My lords, Mahanadi Coalfield Limited versus Sri Ram Construction and others. There, my lords have dealt with. Same thing, my lords reiterated. My lords, it is well settled position. I don't dispute that reappreciation of evidence is not permissible. Is not acceptable. Of course, my view is
only Sangyang is the
that is my lords
has some actions.
Yes, my lords have also dealt with this judgment. Refer to that judgment.
Have you read Sangyang?
Yes, man. Sangyang judgment. My lords have read.
You read Sangyang slightly different.
Slightly different. But here in this case, in case of appreciation of a law, also there is a necessity of appreciation of some fact.
Yes.
There, my lords, this is a necessity. That exception is all along available here. That is what my lords have categorically said when there is an error of facts. Probably my lords meant that error apparent on the face of the record. That is what my lords. My humble contention here in this case. So far limitation is concerned, my learned friend said about what has happened during that
very
period.
Frank and honest. I'm just expressing my. This is academic. The arbitration law is still taking shape. It has not shaped yet.
Yes.
The
No, it's not
arbitration law every day it is taking shape.
It's taking shape.
So it is not. I mean, many things are
complete. It's not complete in this.
Every day and one new thing coming.
It's a
Every
fact.
aspect is being taken. I mean,
It's a fact, my lords.
every case has its own.
It's a fact, my lords. While
and the law is still not settled.
it's not stable.
It's
Like
only 200 or 300 judgments so far.
So
jurisprudence is very limited. So you have to.
That's correct, my lord, that's correct. Only thing, my lord, I will point out, my lord, to shortcut the time because time is very short with me.
Yes.
My lord, so only thing is that, my lord, kindly, my lord, put me a very relevant question, whether I've raised those points before the learned district judge. Means learned court, my lords, where, my lords, I filed the petition as a petitioner. But there, my lords, my learned friend referred to that judgment. Kindly have a glass to paragraph, page 4 of that.
Yes, page 4. Yes.
Means para 3. Page 4, para 3.
Challenging the validity.
Challenging the validity of the award, the petitioner has contended that. Once, my lords, let us ignore it. One, no necessity. I'm conscious of my position, that is what I'm shortcutting. My lords, then 2. The learned arbitrator has not taken into consider the question of limitation as per section 43 of the Limitation Act, and the claim barred by term have not been duly isolated from the other claims. The contingency is different. In some cases, so far some bills are concerned, may be coming within the purview of the limitation. Some might not be coming within the purview of the limitation. That is what, when the bills are under process, these limitation aspects should have been gone into. That is what my humble contention is. Not that the subsequent developments and subsequent action have taken for recovery of the money is a cause of action so as to avoid the limitation, my lords. That limitation law says, my lords, I did not report it. My section 3 itself speaks that. Section 3 clearly speaks that. Section 3 of the Limitation Act clearly speaks that. That even if something, unless and until I rectify the situation, then this cannot be. Limitation cannot be taken care of. So cannot be ignored. Limitation cannot be ignored. Yes. That is the law. So far that interpretation of Section 3 of Limitation Act is concerned. That is what the second part. Then, my lords, kind of a glance to, my lords, about VI, page 5. Yes. The learned arbitrator, without considering other materials, properly relied upon joint verification report and without examining its correctness, and by ignoring the objection raised by the petitioner, held that the petitioner was liable to pay 238 number of bills. Here in this case, the question is that there is no necessity of appreciation of any evidence because the learned arbitrator appreciated it. But the question is that after appreciation, the learned arbitrator has placed its reasoning. Whether the reasoning is right or wrong, I am not on that. There is no dispute that 238 bill is not traced out. It is his case because there was a joint inspection. It is his case, it is my case. He accepted the joint inspection report and the learned arbitrator accepted the joint inspection report. The joint inspection report itself speaks that 238 bills are not available. No appreciation of, no necessity of any appreciation of evidence. Okay. It requires only thing that the reasoning the learned arbitrator developed. That is what I say, my lords. I am carving out an exception, completely finding out the same concept of evidence, finding out of grain out of the chief, also find out grain out of the chiefs only. But thing is that the learned arbitrator categorically stated that these bills are not available, has taken note of that, has also considered that these bills, in spite of due diligence, these bills have not been, my lords, proved that acceptance of the bill have been proved by the claimant. Then only, if I come to a conclusion, the documents are not available with me, and then it is admitted position that these bills are not traceable, thereafter the learned arbitrator come to a conclusion that you are bound to pay. On the reason that, yes, I presume that it might be given. It is not a case of appreciation of evidence. It's not, I may vehemently argue, my lords, in that concept. It's not a case of appreciation of evidence. It is a case, whatever evidence available cannot bring such a reasoning. And the reasoning you refer to justifying 238 bill is not justified. It's contrary to the public policy. Okay. If it is not proved that the bills have been given to me, if you are submitting a record, says that I have given the bill, the record does not contain my acceptance. Somebody will come and say that, yes, I have accepted, then you say that you pay me the money. That is what the contention. I'm concentrating on two things. I'm not saying that my learned friend client is not entitled to so far that other claims are concerned. I'm limiting in so far that limitation for whole. Means he should have cases that the learned arbitrator would have ascertained each and every bills and could have tested tested it, then whether it is barred by limitation or not. That is the contingency so far Limitation Act is concerned, Section 3 is concerned. So far 238, you have said and you have given, subscribed a reason. There is no dispute that these bills are not available, but subscribe the reason whether the reason is justified. That is under testing. That Lorned District Court refused and rejected. I am going to reappreciate the evidence. Where is the contingency of reappreciation of evidence?
Okay.
Then, my lords, my contention is that then kindly have a glass of VIII. There was rather excess payment made by the petitioner to the opposite party to the tune of such and such, which was required to be refunded.
That is your note. You
Yes.
ready for a note?
Yes. No. The judgment of the trial, district judge.
Which paragraph you are reading?
Paragraph page 5. VIII.
Okay.
VIII. The total quantification was there in paragraph 9 of the written statement I filed before the learned arbitrator. There I have categorically stated in paragraph, I can place it because this is my last submission. I place it that my written statement, paragraph 9. I will go through that. I will, if that is not available, I can supply that also. There, I in paragraph there na paragraph 9 ta dekhuntu. Tete gote quantification calculation kari um deichi.
Yes.
There, dekhuntu. Payment in shape of check. Got it?
Yes.
Payment in shape of check, this much. Income tax deduction, this much. Shortage of deduction from bill, this much. Shortage. That has not been accepted, and that amount, that the counterclaim was not allowed. All right, I accept it. Then shortage to be recovered, such and such. Payment made subsequently, 6,34,000. Paid to EPF through attachment. It is your amount. The learned arbitrator consider this, say that yes, the board is not liable to pay any amount recovered from them, but didn't consider this aspect, this fact. Or EPF, we are paying for you. In one side, the learned arbitrator says that yes, the board is not liable to pay or to bear the burden of EPF. On the other hand, didn't recover that amount or didn't say that to set up that amount. But the EPF, the board has paid for and on behalf of the claimant. So there is a divergency, means inconsistency. What my humble contention, there is an inconsistency. Inconsistent to the extent that the claimant claims that I have paid such and such amount towards the EPF, I may be recovered. This may be recovered. The learned arbitrator say that it cannot be recovered because you are not entitled to that. You are liable to pay. You are the employer. You are liable to pay. On the other hand, on behalf of the claimant, the EPF authority recovered from us could not take note of. This is my contention. This is my specific contention. Could not take note of that. Also, I refer to this and I raise my counter claim that this is the claim and accordingly it may be given. Then last part, that is so far in interest component. I leave it to my lords. That arbitration, that the reference, so far the arbitration is concerned, didn't contain any provision for awarding of interest pending during the disputed, not during pending of the appeal or award. Thereafter, the act says.
Okay.
That we cannot manage. This is what my humble submission.
Interest also, your lordship, in that IRB seeks are given the copy.
I am not disputing about the interest. I am disputing about the
that note I have given in the award, the claims awarded and discussed, I have given the para numbers. Okay.
In nutshell, let us not go into this. Only thing is that let us not be benefited in this process. Some lapses in your part, some lapses in my part. I have to be here, some lapses in your part, you have to be. Whatever award, I know that my scope is very limited. Yes. You think two things which haunt me, that is what I am repeatedly arguing. One is 238 bill. The second is the EPF amount. Why shall I pay for on your behalf? And if this amount two amounts, at least I am entitled to percent.
Thank you. Next. 18.
Item 18.
Hoshla.
See, in my lords, the writ petition has virtually become infructuous for the reason that there are 9 petitioners who are due for promotion. Out of them, 8 have been promoted One is already in the zone of consideration, so will be promoted in the next 4 months once the selection committee sits.
So
I filed
right.
a counter yesterday.
Disposite of
I will give a copy. Counter a kali, in the adject before you file. So I'm giving the hard copy.
Give me a
Copy to him also. We'll go through the counter man.
So give me a copy.
Right.
Okay. To file a rejoinder if any you want. So just the matter on 25th.
Right.
Item 19.
Item 19 also they have not filed the counter. Item 19
19
also it has become infructuous. Why? Because the petitioner already been promoted. Twice. Now he is professor. Please take the
Online counter filing.
2017, he was promoted to the post of associate professor. 2022, he has been promoted to professor.
Where is
Instructions, my lord, last para 3 of that instruction.
The petitioner was recommended for promotion to the post of associate professor in surgery, disciplined by the next selection board, held on 23 and current years. 23/11/2017, and accordingly, the petitioner was promoted to the post of associate professor, surgery, discipline, health and family welfare department, that the petitioner has been promoted to the post of professor in surgery, discipline, within paragraph 4. So, in such is the matter. According to the paper that was issued by the health and family paragraph 3 for the in such is the matter. The grievance raising of the letter doesn't say. Next.
Item 20.
20.
May I please, your lordship? Your lordship, in this matter, the counter and rejoinder have already been filed, your lordship. A week's time may be granted to file a written notice of submission, your lordship.
Why? Argue.
Okay, your lordship.
Argue after that, written notice of submission can be filed
Yes,
later.
lordship. Your lordship, here this is a matter where the petitioner stood as a guarantor for the education loan sanctioned in the year 2013 and subsequently in 2015, your lordship.
Education loan guarantee darkar ki?
More than 5 lakhs. Guarantee.
Not required.
Below 5
Below
lakhs.
5 lakhs?
No guarantee, no mortgage.
That's right.
Yes, your lordship. Stood
So
as a guarantor.
what is the loan amount?
Loan amount is, your lordship, 10 lakhs.
10 lakh. What are the study?
Medical student.
Medical student, your lordship.
Medical.
Your lordship, the
Where?
EMI date was starting from.
Where?
That's for that.
The question I'm asking, there is a reason for it.
Now he's a medical officer in Jajpur.
Sir, code
They-
college.
That I cannot say. But he is a medical officer in Jajpur.
College.
Your lordship, on that, I'll take an instruction. But
there are colleges and colleges, you know.
yes,
Employability will question medical college आजिकल जोटे पड़ी गला employment मिली जाउची काहे ना हमर doctor shortage अछि Tom Harry को का कैसी
the EMI date was starting from 2019, your lordship.
after this
Yes, lordship. Yes, lordship.
moratorium period is over now.
Yes,
So
lordship.
starting
But
from
your lordship, 2019 में start होता है EMI.
oh month through
For July, April, your lordship.
कोई भी ना खाली आधा कहउछन.
Yes, lordship. April 2019. But what happened, your lordship? The account of the petitioner was blocked in the year 2016.
क्यों?
16, your lordship, they have stated the reason that collateral security was given by the petitioner, which is not admitted by the petitioner, your lordship. For that, fearing that he will withdraw that collateral security, they blocked his account, his savings account, your lordship. Subsequently, in 2018, they deducted an amount of 4 lakh rupees from his savings account, your lordship. But, your lordship, my contention is that what was the need to deduct the amount when the EMI was starting from, your lordship, 1st of April 2019.
Which bank?
Punjab and Sindh Bank.
Punjab and Sindh Bank.
Sindh Bank.
Now your number Punjab National Bank same
Same.
Talchi. So you have not changed your
What was this?
avatar. New avatar. You have not
Your Lordship, no effort till date has been taken to recover the amount from the loanee and the co-borrower, Your Lordship. But as the petitioner stood as a guarantor, they deducted the amount of.
Father is the co-borrower.
Yes, Your Lordship.
Father.
Yes, Your Lordship.
Okay. So now, if that the EMI starts, then let him pay EMI. Where
It's not paying. We have got a decree from the commercial court also. And
not paying.
no,
Your Lordship,
not
as
paying.
Just a minute. Kete EMI kete aschi mas.
EMI 6,000 was there, Your Lordship.
6,000 dono doctor icho.
Yes, Your Lordship, but that is not my concern. Yes, that.
Your guarantor.
Yes, Your Lordship.
There is a saying na. There is a saying la. Je कौन हैला असुविधा तंगरो. से पैसा दोनी. आगो ताको धरन तो सेट नहले आगो धरबे ना. सीधा डायरेक्ट आगो धरबे.
He is able, he can prepay, but they have.
You just catch that man. If he is not paying, you catch them.
We have also filed a suit against the main borrower and the co-borrower. In that case,
suit file करे काहे जो education loan न देवले तो ए बैंक में ना लोन देबे पिला उनको तम भले लोग बाहर तो सरी गला कथा तमर जो जहां को देई छ तमर पुत्रा चाचा भतीजा जो भी है तो से आ लोग देबे बैंक लोन देबो का एंदी कोला
Lordship, he is a retired person, savings account.
अरे रिटायर्ड तम पिल्ला कोची जो चाकरी करची जो सो कॉल मेडिकल स्टूडेंट पैसा तो नला अलगे नलो पाठ पढ़ी साइलो को लोन देबो सीधा कहते 6000 टका दी पन सिगरेट पी दूथो 50 देगी हां
from the commercial court. Execution proceeding is continuing. In the meantime,
ଗୋଟେ କାମ କର ସେ ପିଲାଟେ ମୋ ପାଖକୁ ଆନ ମୁଁ ସଲ୍ଭ କରିଦେବି ସବୁ
doctor.
ଆ ସେ ପିଲାଟାକୁ ଡାକ ଏ ତମର ସେ ଯୋଉ କଣ ନା ପୁତ୍ରା ତ ପୁତ୍ରାଟାକୁ ଡାକି ଆଣ କେବେ ଆସିବ ସେ
Lordship, I'll take in.
ହଇରାଣ ହବ କଲ୍ ହିମ୍ ଅନ୍ 13 12 ତାରିଖ ଡାକ ହେଲା ଯାଜପୁର ପୋଷ୍ଟିଂ ପରା ଗୋଟେ ଦିନ ଆସିବ ଏଠିକି ଆସିବ ପର୍ସନାଲି नो ଏଥିରେ ନାହିଁ ଗୋଟେ ଦିନ ତାର ରୋଗୀ ସେ କେମିତି ରୋଗୀ ସେବା କରୁଥିବ ଡାଉଟ୍ ଲାଗିଲାଣି ମତେ ହେଲା ଡାକି ଆଣ ଗୋଟେ ଦିନ
he is getting well.
ପିଲାର ଚାକିରି ଯିବ ଡାକିଦବ ହେଲା ନ ହେଲା ବେଳେ ତା ଚାକିରି ଯିବ
My lord, he is getting 1 lakh rupees salary every month.
ଆରେ ଦେବ କାହିଁ ବ୍ୟସ୍ତ ହଉଛ ସେ ପଳେଇବନି କୁଆଡେ ବହୁତ ଲୋକ ଏଜୁକେସନ ଲୋନ ନେଇକିରି ପିଲାମାନେ ପଢୁଛନ୍ତି କିଏ କିଏ ଗୋଟେ ଗୋଟେ କଣ କହିଦେବ କାର ପ୍ରୋବ୍ଲେମ ଟା ବୁଝିବା ସେ ଆସୁ ଟିକେ ବ୍ୟସ୍ତ କାହିଁ ହଉଛନ୍ତି ଆସୁ ବ୍ୟାଙ୍କ ଏତେ ଲୋକ ତ ପଳଉଛନ୍ତି ଲୋକ ଧରି ପାରୁନ ଆଉ କଣ କହ ଏଇଟା ଛୋଟ ଛୋଟ ପଛ ପଡୁଛ ଚାଷୀ ପାଖରେ ଗୋଟେ ସେଥିରେ ପ୍ୟାକ୍ କରିଦବ ନେକ୍ସଟ କଣ ଅଛି
Matter relates to disengagement of Gram Rozgar Seva.
ଗ୍ରାମ ରୋଜଗାର ଗ୍ରାମ ରୋଜଗାର କଣ ହେଇଛି କଣ ହେଇଛି
The error happened in the face of record, how it is predetermined to oust him from the job. A particular work is assigned to Gram Sathi. See, allegation है जे से लोक न लगे कि machine लगे काम करा. That is the allegation against that. Against that, he was the Gram Rozgar Sevak was terminated. And subsequently, Gram Sathi said and came with application. Due to some difference, I have lost that complaint. Now it is settled. We have done the work properly. Without considering all these things, without conducting inquiry, and Lordship will surprised to see.
যদি সেটি এটা অ্যাকচুয়ালি কোন এমজিএনআরজি রে কোন ଲୋକଙ୍କୁ କାମ ଦେବେ କାମ କରିବେ ସେ ମାଟି ଖୋଳ ମାଟି ପୋତ ଏଇଟା ତ କାମ ଆଉ ବେସିକାଲି ହଁ
That was assigned to Gram Sathi on record.
ହେଲା ହେଲା ଜଷ୍ଟ ମିନିଟ୍ ଯେତେବେଳେ ମେସିନ ଲଗା ହୁଏ ଏତେ ଲୋକ ନାଁ କୋଉଠୁ ଆଣ ଅମିତାଭ ବଚ୍ଚନ ଜିତେନ୍ଦ୍ର ସବୁ ଲେଖିଦେଇଥିବ ଲୋକ ନାଁ ପାଇଲେ ଲାଷ୍ଟ ଜଜ ନାଁ ବି ଲେଖିଦେଇଥିଲା
Termination order.
Now, so you are challenging the termination order.
Termination order
on the ground of
on the ground that without following due procedure,
Okay,
without
good.
opportunity,
Okay.
your lordship kindly see
ସେଟା
one
ହେଇଗଲା
page-
ଦିଟା combine
sir, page 17 ରେ ଟିକେ ଦେଖନ୍ତୁ page 17 ରେ 5 ରେ sir order ହେଲା 7 days ରେ show କରିଦବ loss is as per their guideline 30 days is mandatory sir ଟିକେ ଦେଖନ୍ତୁ 17 page ଟା ତାକୁ order issue କଲେ sir 18 ରେ 5 ରେ sign କଲେ collector side 18 ରେ issue ହେଲା 7 ଦିନ ଭିତରେ
କୋଉ district
sir page 17
କୋଉ
କେଉଁଝର
district?
କେଉଁଝର sir Lordship, kindly see, order was signed on 5/5. You have to file this show cause within 7 days. Orders are issued reported. Kindly see.
ଏଟା କଣ reply ଦେଇଛନ୍ତି?
Regular.
File reply.
Yes, my lord. He filed his reply. It was.
You.
We have
Yeah.
filed at counter. Your lordship may kindly come.
You have filed a rejoinder.
No,
No, no counter has been received.
Give the counter file rejoinder.
Counter file लेने-
Final argument में
Counter
रखो.
copy देना है.
16 रुपए.
List पर final argument on 14 है ना?
Obliged. Please give a counter copy. Please.
Counter copy देंगे. ना government कौन माने special privilege का rejoinder you have to file rejoinder.
1 week time. Short date maybe.
1 week time may be granted. 14, 15, 17 third दे दे. 21. 24.
24.
24 minutes, I'm seeking for a short adjournment.
Sorry.
I'm seeking for a short adjournment, minutes.
When do you want?
Any date after September 15 minutes.
September 15. Okay, 22nd.
Obliged, minutes.
25.
25.
25. I have a matter relating to termination of the GRS. They have filed counter. I have already filed rejoinder.
Final year. Final year से 22 रास.
My lord, for 4th, my lord.
हाँ?
Next week, my lord. Next week and
Next week. Oh, 15 रास. 15. 15. 15
Because of your lordship is here, matter could be able to hear.
So 15.
And also my lord and friends able to
15
file
रास.
counter.
15 रास सुनिए. 15. Okay. 25 से ऐसे था.
26.
ऐसे था.
मैं
आ जाए. Now 26 कौन?
Your lordship, kindly see the last order dated 1st of October 2000, sorry, August 2023.
कौन कहूँ ना?
Your lordship has directed the petitioner to implead another person who has filed a writ petition and
I filed the I petition for implead the party and the
Implead.
and that is console to cost item.
Okay. Impleaded constant is allowed. Okay. State and copy दे दो. कहाँ को implement करें? Notice issued to the
Opposite
impleaded.
partner 5 madam.
हाँ?
Opposite partner 5 madam. Console to cost.
ना कौन?
Sudharani Mishra.
Sudharani Mishra.
Sudharani Mishra. The impleaded party may be issued notice by registered post today. This is the matter on 29th. 29th.
Request will file within 3 days.
Within 3 days. Without saying that. Next. 27.
27.
Last time you were also directed to take instructions from the government council.
27.
My lord.
It is happened.
More.
27, your lordship has directed us to just find it out whether any Asa Karmi has been engaged or not. Till that, nobody has been engaged. my lord.
So,
when the present petition stood fast, my lord, but till today no appointment has been given to the concerned petitioner, my lord.
she has been appointed, finally selected.
Why she has not been engaged, that
That
is
you
to-
take instruction. And consequent the petition, the state to take instruction. That's why the present petitioner has not been engaged. Next.
But dead may can please.
That is like this. See, pack up with this. Say that. 22 दे दे. 22 तो छोटी.
Obliged, my lord.
28.
Item 29.
29. 29. ये petitioner 9.
Antibode.
Non-appeals for the petitioner.
Matter is infructuous, my lord.
ठीक है?
हाँ.
कौन है?
ସେଥିରେ actually ସେ ଯୋଉ scheme ରେ apply କରିଥିଲେ bank କୁ ସେ scheme actually ଗଲାଣି 2009-10 ବେଳୁ apply କରିଥିଲେ.
Non-appeals for the petitioner, Lord Constitutional Bank submits that this scheme under which the petitioner had applied before the bank is no more in existence, hence the petition, the cause of action raised in this petition doesn't survive anymore. This dispose of.
30 ରେ 30 item ଟା ହଉଛି ଆଜ୍ଞା
Item 30.
30 ଟା ବି infructuous.
Same order.
ନାଇଁ 30 ରେ କଣ ହେଇଛି ନା ଏ ଲୋକ ତାଙ୍କର already departmental proceeding ହେଇକି ସେ another writ application ଆଉ ଗୋଟେ file କଲେଣି ତ ଏଇ writ application ର ମାନେ କିଛି ନାହିଁ already infructuous.
ସେଇଟା ଛାଡିଦିଅ।
Your lordship kindly fix
ଏ
a short
29
date.
29 ଛାଡିଦିଅ। କଣ ହେଇଛି ଆମେ ଜାଣିବୁ।
ତାହେଲେ ଗୋଟେ ଛୋଟ date fix
29
କରିଦିଅନ୍ତୁ।
ହଁ
Next week any day your lordship.
22nd ଆସୁ।
Oblige me lord. 22nd.
22nd
ଆଉ ଟିକେ short date ହେଇଥିଲେ ସରିଯାନ୍ତା।
ଆଉ କଣ ଆସୁ 22nd ଆଜି ପାଖରେ ପଳେଇଛି। ଛୁଟି ଅଛି ଗୁଡାଏ ମଝିରେ।
If possible your lordship.
ଗୁଡାଏ ଛୁଟି ମଝିରେ ଅଛି। ନେକ୍ସଟ
Item 31.
G20 ଅଛି।
Oblige me lord.
So ଟିକେ ଅଟକି G20 ରେ କିଛି କାମ ହବନି।
The loan with the HUDCO
सारा देश लॉकडाउन में होगा।
has been already closed. Lord, this is infructuous matter. I am
कोड़ा एटा
item 31, my lord. I am for the HUDCO. The petitioner
31
petitioner had taken a loan from HUDCO
so कौन है
on the guarantee
On behalf
from,
of Mr. Mahathi, may be taken up next week, my lord. He is
I have
suffering
filed
from
the
fever.
detailed counter affidavit.
so
We have already filed the rejoinder also.
okay 15 रे आसु नेक्स्ट चंद्रशेखर मेडिकल स्टोर भुवनेश्वर पड़ेगा अमित प्रसाद बोस टाइम मुने रे टाइम ये टाइम पार्टी नहीं शायद 33
Item 33.
33. This case, my lord,
हाँ एटा इशू टा कौन
petitioner was a young lady applied for on a commercial broiler project under self-employment scheme on a state agricultural policy. Scheme contained capital investment subsidy. Project has been completed. Project has been completed. But subsidy is yet to be released.
which department
Apical, my lord.
huh pickle yeah appearing for that or some other concepts are there
Apical will be appearing.
so what is your answer have you if he has completed why have you not received this
Opposite party number 7 is the managing director Apical.
so ଆପଣ reply କଣ
We have already filed the reply. We have already, the Apical has withdrawn that subsidies, my lord.
why
That Apical has to answer me.
so appeal is different council
My lord.
that's what I'm asking who is appearing for appeal
I am appearing for the
appeal
Apical.
so why you have not given that subsidy
Sir, I take instruction, I will take instruction.
give him a copy give him a copy
Direct already served the copy.
okay
So there is a direction of this honorable court.
ठीक है वर्तन हाँ honorable court केते direction दोची छाड़न अबे
No, 15 दिन भीतर
press आपण कोन instruction दियंतु हला list the matter on 15 as you take the instruction on concept the apical mr to raise the court about the issue raised in the present regulation list the matter 22nd as 22nd
22nd.
next
Item 34.
34 34 what is the issue
Taken the loan, I have offered the amount on annexure 12 my one-time
for the
settlement
amount माने
for one-time settlement that was denied. Out of 9 lakhs something they are demanding, I am negotiation was going on. 6 lakhs 5,000 I have 50,000 I have offered and that was denied.
ओय आपण कोन कोठपु सरकार जे आपण सब जहा कहबे सेटा मानिबे से माने
At 7 lakhs
Sir, OTS mean there are a lot of sacrifice by the bank.
मतलब 7 lakhs
जहाँ
7
इच्छा तापन दे देबे सन मानते
मतलब 7 lakhs 17,000 they were demanded. Thereafter I have paid 1 lakh something, they are not adjusting that. That's the dispute. I have already solved the copy, Mr. My
ना
lord,
solve
Mr.
करे ना
Aravind Mohanty was directed to.
ओडिशा ग्राम्य में
I have given the copy.
copy
I have given only the copy.
okay 17 रे आउथल हला call him on 13th we'll see.
Obliged.
35.
35 lord, we are supposed to file written note, we are
Yeah.
filing today.
File the written note 36
One just small prayer, my lord. Earlier I have given certain judgments, I am not duplicating that here, only residual judgments which I am supposed to give, I have given.
okay
Grateful.
36
Reserve for judgment, my lord.
36 are already.
35 reserve.
yeah
36 was mentioned earlier.
Oh,
Again,
mention. Okay. 37,
37.
Padma Silk Palace, Tuna Sahu. कौन है सिल्क पैलेस?
1974 मोर लोन थिला
बैंक ऑफ बड़ौदा।
बैंक ऑफ बड़ौदा रो मोडे प्रपोजल देइथिली कोटी 65 लाख रे that proposal is my brother is saying rejected I will
केते रे हां करबे कोन
तार आउटस्टैंडिंग होची 3 को जो 2 कोटी
माने
50 लाख
एते जरा केम दिया
मिलर 5 times the property was placed for auction but auction was failed due to non participation of the bidders. Actually value of the property
कौन करिए वो कौन तो ठीक है हेल्प करन तो कौन बैंक वाला किसी करिए ना
value of the property
Mr. Tuna Sahu bank counsel he helps many you also help
the value of the property is much more than the loan average. Consider OTS consideration हबने
2 कोटी 20 लाख टंका रे माने लास्ट टाइम से माने करथिले नोटिफिकेशन करथिले ऑक्शन टा फेल हैला एबे से कहउचंदी जे कोटी 65 टा एबे हेई परलान कोन देइचन चिट्ठा
रिवाइज फिक्स करना
I will file an
रिवाइज केते हैला इंडिकेट करले सर पड़े
केते टंका रहबो कहले
आपण इंडिकेट करंतु
5 थर ऑक्शन फेल हैला 5 जन 50
लर्न काउंसिल petitioner to approach the chief manager cum authorized officer Bank of Baroda Ganjam Barampur Ganjam and the said manager shall consider the OTS which will be conducive to the bank and also and if the petitioner agrees the matter can be settled amicably. Allah. Revise OTS.
What a proposal within a week I will submit with.
To proceed with the revised OTS and if it is acceptable to the bank shall consider in accordance with the law. And the corner finish time.
3-4 having filed before this
my intention to close this issue. I don't want to.
Let's fix it.
Do one thing. Within 15 days, within 15 days.
Yes.
And the issue the banks and the bank and the petitioner shall explore the possibilities of settlement in a congenial atmosphere and settle the issue at the earliest possible.
And they will consider sympathetically my consideration because they are
explore
obliged.
They will have a sympathy. Bank of Baroda people are good people. Don't.
I'm an individual person. He's a big bank. I cannot.
Big bank. All the banks are big.
My lord, seniority appearing
for many big banks. Many big banks.
The karma.
Many big banks.
My intention to close this issue.
Yeah. Okay. Let's see.
Capacity matter out 15 days.
15 दिन भीतर में time नहीं था तब पर देंगे 29 days है ना 29. Okay, next.
My lord, it is a very serious and sensitive issue, my lord. Your lordship, while issuing notice, because the lordship on that date assured me that I am giving 1 month time to them. If they will not come out, we will protect you. That's why I am.
What is the issue?
My lord, this child line, they're giving it to the police, thus no art. That they have changed to now the police state-wise. That is one central scheme. And that is every center has that thus no art in distressed children, whoever calls them.
Your grievance is what? What is your grievance?
My grievance is we are child line protectors. And now our job is at stake because they are not, government has not come out with any instruction or counter what they're going to, how they're going to operate. Now they are deciding to have new recruitment for this job. That is my grievance.
So,
your lordship
anything, any instruction?
They're for government, central. They don't have anything to say. This is
state government.
State government has on 3/8. Your lordship was pleased to issue notice and come up with a policy reason.
Indian government, your lordship. But I,
And next on the challenge. the
Union
order-
government.
That the state has to take, we are the child line
But
protector.
we are challenging what? Union
I am
government not doing.
challenging.
Union government not doing.
annexure to the.
So you have your reply.
No, 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 no,
But
annexure to my
I am
lord.
appearing today itself.
My lord, I am,
I'll
what
take
I am
instruction.
challenging, my lord, kindly see.
Which
Page 18, annexure 2. They have Baschalya scheme, they are just renamed the packaging Baschalya scheme.
the
and
government of India, madam.
Government of India, they are master in that. My lord,
So government, let government.
no, no, my lord, it is all India, pan India, my lord. Paragraph
Who
2.
will reply?
Government, state government. Because,
No.
because my lord, paragraph 2 kindly see. In this regard, all the states and UTs were requested to identify a state level nodal officer and the second level, that is their procedure. Now it is.
No, but this is the
I am-
state government is going to implement a central government direction.
No, no.
Yeah, central government direction.
Because they are decentralized. The state has to do it now.
Obviously, it is, see, this is an issue of federal, it is a federal,
Yes, right.
federal
my-
issue.
So I want whoever, my lord, that our job may be.
You take instruction both.
My
of
lord,
them
but
file it.
kindly see, my lord.
Let them file the
Tamil Nadu has adopted that.
Let them file the reply.
Yes, my lord. Then your lordship may protect
State
me.
as well as the central will file the reply within 15 days.
My lord, your lordship may protect me till then.
Inti protect karibi, ଗୋଟେ system
ଦରମା ଦଉନାହାନ୍ତି ବର୍ଷେ ହେଲାଣି my lord କାହିଁକି see?
ଆଉ 15 ଦିନରେ କଣ
ଆମେ 15 ଜଣ ଅଛୁ my lord
ଆଉ
because
Instruction has.
this is up to step level
let
fast.
them do.
My lord, this is
Because
up-
I can't disturb something if central government wants to
Then
change it.
they have not come up with any definite plan, my lord.
Let's
Now why
Let
children
them
will
file
go?
the reply. Let them file the reply. You have to just wait for their reply.
My lord,
Let them file the
the
reply.
last one month they could.
Can't reason देखिए.
My lord, last 1 month
You
we are
know,
working.
You know state center how they work. So
This
they have a
I
material
know I have no grievance against the center, my lord. I have no grievance because in the electioneering they will
Done.
never do anything. My lord, against
done
the
like
state,
that.
my lord, against the state, I have a grievance that they are not taking any step towards.
Because that is bad. Now it is direction of the central government. सबको डरते सब डरते
No,
central government.
31st, they have given notice in December that it will stop on 31st
Let's
August.
see.
My lord,
Let them file.
my apprehension is now in election.
Nothing will happen. Don't worry.
No, they will recruit their own party persons as.
Oh, केमती अपन जान ले
ଏତେ ଇଲେକ୍ସନ ବେଳେ ହୁଏ ନା ସବୁ ଆଜ୍ଞା ତାଙ୍କର ବିଜେଡି ମୟ
एस्ट्रोलॉजी देख लेनी एस्ट्रोलॉजी
ତେଣୁ ମୋର କହିବା କଥା ଯେ ଆମକୁ ଖାଲି ପ୍ରୋଟେକ୍ସନ ଦିଅନ୍ତୁ ଅପ୍ ଟୁ 15th
आसु नेक्स्ट डे
ସେଇଟା ନେକ୍ସଟ ଭ୍ୟାକେଟ କରିଦେବେ so that I can say
କିଛି
that
ହବନି let them ଏତେ ଦିନ କିଛି ନେବେ କାମ
ହଁ ଏବେ ସରିଗଲା 1 ତାରିଖରୁ
15 ରେ କିଛି ହବନି
but this will come first.
let them come we'll see that. Okay.
My lord, your lordship will not protect us, my lord. These honest people, then where they will go, my lord? And this, my lord, this come will end on
Government is going to have a plan. We can't disturb.
because last
If
3
I
months.
protect you, then I am disturbing their program.
No, my lord. I will quit if they have any other problem.
That's why let them come with their
If
reply.
police will once interfere, my lord,
Let them come with their reply. We'll see that.
and our salary, my lord, say that, my lord, for last 1.5 years,
That I'll ensure that. Don't worry. Salary will get sure. For sure.
J Sahu along with London DSJ for OP4.
the lordship, my lord, came to bar 12th.
Very short date.
12th, my
15
lord.
दिन पर दे दो
12th they did.
Yeah,
Well,
so your instruction.
15 आसु 15 आज ही 15 दिन ना 16 15 ठीक है 18 आसु
My lord.
18
18th.
okay next
My lord, 15, my lord.
नहीं 15 दिन तो
I have had press with
18 15 16 17 18 कहते हैं 18 the next
My lord, I may be
39.
pardoned, my lord. I may be pardoned to cause inconvenience to my lord, my lord. Item number 29.
29 कौन हला
I am for the petitioner, my lord.
कौन हला कौन
ଏଇଟା କଣ ହେଇଛି ଯେ ମତେ loan I was sanctioned loan.
तो कौन है कि कौन 29
22nd.
22nd एडजन नीचे आइबे कौन अछि 22nd एडजन नीचे किछि
22nd.